D.C., and the former President Robert Altman. We now bring you the remainder of the hearing.
Thank you, Senator, for arranging the break.
Delighted. Hearing will come back to order. Welcome you back and remind you that you stand sworn already before this committee today. Let me just announce that we are going to have normal Senate interruptions here in a little while. I think we have a string of back-to-back votes sometime around 3:30, and what we'll do is try to hang in here through the better part of the first vote and then go over and take a short recess, which I'm sure you won't object to, so we'll proceed from there. There are a number of areas yet to go through, and I'd like to continue to do that. Some of them, again, like this morning, raise some tough questions, but on the other hand, you've both proven yourselves capable of dealing with the tough questions, and I hope that this is proceeding in a way that everybody feels is fair and sensitive to the process. Turning your attention now back, Senator Brown has sort of inquired about the stock transaction, and I think what we're dealing with here is not necessarily a single instance in any one place that leaps out and says, hey, something wrong happened, but a question of a larger picture that people are looking at, sort of a conglomerate effort. And I think that's what I think the committee wants to try to answer today. And I also want to assure you the committee intends, and we want to get some questions in generically about this, about the lessons to be learned, about the responses, about what this does or doesn't represent, about the conclusions that you both draw as a consequence of what has happened. Some of those conclusions I know are very obvious. Let me raise one issue that, and this has been a problem for the committee since day one, and I think you know that because we expressed that to you previously, and that's just sort of been the production of documents and records. And this may be something that counsel wishes, that your counsel wishes to address, Mr. Bennett, but we have sought a series of documents, and we have sought their release now from the liquidators, who are sort of BCCI at this point. And some of those documents, it has been asserted by you, because you are the attorneys for BCCI, are protected by attorney-client privilege. And we wrote requesting some of these documents that you be released from the attorney-client privilege by the liquidators who represent BCCI. The liquidators, in turn, have requested from you that they see some documents in order to determine whether they want to release these documents. And we have a list of some 20 documents. We received a letter from Mr. Bennett on October 23rd, 1991. In response to your letter request of October 17th, please find an index of documents withheld from the subcommittee on the basis of the attorney-client privilege and/or the attorney work product doctrine. And you've identified those by date, author, addressee, and type, and there are some 20 of them. My question to you is, why, given the fact that we want to shed light on this thing, and you do, and you're not willing to waive that privilege from or is that something you can't do at this point? Does it have to be done only by the bank? Is there any reason the bank doesn't have the documents? Mr. Bennett, if you want to respond, I invite you to the table to do so.
I think it would be best if our counsel responded.
All right.
Senator, this is Mr. Clifford and Mr. Altman have never asserted any privileges on their own behalf. There is a very complicated issue as to who can speak for BCCI and waive BCCI's privileges. I'm advised that daily representatives from country after country are coming forward and claiming that they are the liquidators, and lawyers come forward say they represent the liquidators. And we have advised that until we are certain as to who is in a position to waive privileges on behalf of BCCI, we feel that we have no alternative but to respectfully submit to you a letter such as we submitted to you, where we identified the documents and the basis for their being withheld. We could be exposed. My clients could be exposed if they submit something without there being clear authority to waive. And in simpler times, Mr. Chairman, when it was reasonably clear who did represent and what BCCI was, we were advised that they did not waive the privilege.
Well, let me ask you a question here. Appreciating what you have said, their last attorneys of record, Patton and Boggs, inform us that Nussbaum and Wald represent the liquidators in BCCI. Nussbaum and Wald have indeed asserted that notion, and they have, I believe, written to you saying, let me just find the appropriate letter here, and I apologize for...
I'm familiar with the letters.
All right. We received a letter from them to us, hand-delivered October 23rd, yesterday, and they said, we write in response to your letter requesting that our clients, the commissaires of BCCI Holdings, appointed by the District Court of Luxembourg, the commissaire of Bank of Credit and Commerce International, appointed by the District Court of Luxembourg, the joint provisional liquidators of Bank of Credit and Commerce International, appointed by the High Court of Justice in England, and the joint provisional liquidators of Bank and Credit and Commerce International Overseas Limited, appointed by the Grand Court of the Cayman Islands, waive BCCI's attorney-client privilege with respect to certain documents referred to in the October 11th response. So they have indeed acted to waive. Their problem in not being able to waive fully is that they haven't gotten the documents from you.
That's only one part of it. There is an assertion that they waive, but what they are waiving is whatever power they have. The issue of what power they have is very complicated. I have the highest regard for that law firm, but Senator, I can assure you that the issue of who BCCI is today and who has the authority to waive the privileges, is by no means clear. There are, as I say, based on inquiries I have made, liquidators coming out of the woodwork, literally, Senator, claiming that they represent BCCI. And I respect...
Well, are you challenging the authority of the bankruptcy court in New York with respect to this proceeding?
I'm not challenging the bankruptcy court in New York. What I am saying is that there are claims throughout the world as to who truly represents BCCI in terms of the power to waive privilege. It is a very complicated issue, and I would respect...
Well, we're talking about United States jurisdiction, aren't we?
We are talking about...
I'm not sure that they'd have a right to withstand a subpoena from the Senate of the United States on that basis, would they?
I'm not quite sure I understand. Who withstand?
Well, if we're operating within United States jurisdiction and the documents are in the United States, and the bankruptcy court, which is the only entity that I know of in the United States of America appointed to deal with this matter in this country, is willing to waive privilege, what is the issue? There's no jurisdiction of another country over those documents.
No, what I'm saying, Senator, is I'd have to study the bankruptcy court opinion. I do not think that bankruptcy court opinion establishes who has the power to waive the privilege.
Well, they obviously have waived it as to the matters that they have already looked at.
To the extent they believe that they have it, Senator. I'm telling you that I've made inquiries.
So you are challenging their power?
I'm not challenging the power of the court. What I'm challenging is that it is very complicated at this point to determine who can waive the privilege on behalf of BCCI. I understand, Senator, that it is not even known at this time who owns BCCI, quite apart from the issue of the original nominee status. This is something that the liquidators, all of whom claim powers, and I don't believe that they even recognize necessarily each other's powers. It's something that's just going to have to be resolved. I'd be happy to work with your staff on it, Senator.
The questions that we have submitted are questions with respect to compliance with the United States Senate subpoena. They are not questions that involve any foreign ownership or any foreigners.
I understand, Senator, but there are privileges of work product and attorney-client privilege that are well recognized in the courts of this country, and the only thing that we're asking is therefore to be a definitive answer as to who has the power to waive the privilege on behalf of BCCI. And I respectfully submit to you that is very much in dispute. I'd be happy to work out with your staff. I'll contact the various liquidators and see if I can get an answer to my question.
I would obviously appreciate that.
Thank
and
you,
if we
Senator.
can try to do that, that would be helpful. But this is, may I say to you, this is, given what we know about what is purported to be the substance of some of those things, it's the kind of thing that sort of just raises another question mark and makes us, forces us into this kind of dialogue.
I understand, Senator, but I ask you to please understand.
I respect that, and we'll try to work it out.
As
We'll
you
see if we
noted
can work it out.
earlier, we've been fully cooperative with you, and
Let's see if we can work it out.
we'll try to work it
Let's
out.
try to work it out. Let me come back now to one of the other critical issues here. There are a number of issues that still remain sort of part of the overall puzzle. And we need to ask the questions in order to understand the relationship, because so much has been written about it, and it's obviously part of the pattern that the documents set in front of us. This morning, in response to my questions, Secretary Clifford said that there was indeed a separate management and that there was a separateness in the undertakings, notwithstanding that Mr. Abadi would advise that there would be an advisory role, so to speak, representing the shareholder interest. What I would like to ask you to do, if you would, please, is addressing document number 11 to start with. This is, and these are just a sampling of the documents. Needless to say, as I said earlier, this is not a forum in which to we're not going to go, and we just don't have time to go through everything. But looking at the document number 11, it is a Bank of Credit and Commerce International stationery, and it is a Mr. Crusoe Karamat Eli, and I think you know who Mr. Eli is, correct?
Yes, sir.
Mr. Eli worked for First American at one point.
Yes.
Do you remember what period of time?
He joined the bank officially in July 1983. I think that's what the records indicate, and was active in the bank until this year.
What was his job? What was his title or his office in the bank?
He was a senior vice president at First American Bank of New York. I think he had different functions over the years. They involve financial planning and the like.
At the time that he wrote this, October 14th, 1982, he was submitting to a Mr. Shoaib of the Central Planning Division at BCCI London a monthly performance report for the month of September 1982. And he says, enclosed is the report of certain activities of the representative office, that's BCCI, for 1982. Notable exceptions not included in the report are as follows. 1, attending the IMF conference held in Toronto. And 2, this is what I'm interested in, advising First American Bank in the acquisition of space for their New York bank. Signed, Mr. Eli. Now, why is Mr. Eli of BCCI doing a monthly report to BCCI about the acquisition of space for First American?
Senator, I can answer this if you would indulge me. Let me put this in context. First, I might say that, to the best of my recollection, until last night, I had never seen this letter before or the other letter under this tab. So it's a little hard for me to say what the author of the letter had in mind. I had never seen it and had never discussed it. But I can describe for you what was happening at that time period, which I think would make sense of this. We completed the regulatory proceedings relating to the acquisition of First American before the Federal Reserve in August of 1981. We still needed to get one final regulatory approval, and that was from the state of New York. And we went before the state of New York, and it was a very difficult situation because of political and ethnic considerations that arose in the context of those proceedings. And our application before that banking board in the fall was initially rejected and denied. And we then had discussions with the staff of the banking board, and at that time, Financial General, the company being acquired, the predecessor to First American, owned two banks in New York State. One was a very small bank in Albany, New York, called Community State Bank. It was about $75 million in assets, as I recall. The important bank was called the Bank of Commerce in New York City, a much larger bank. The Bank of Commerce board opposed the acquisition. They did not wish to be acquired, as often happens in times of corporate acquisitions, and had opposed this before the banking board. Ultimately, a resolution of the matter occurred when the group agreed that if the application were approved, the Bank of Commerce would be sold. Indeed, it was to be sold to the directors. That was the original agreement, although they ended up not acquiring it as they couldn't raise the financing, and it was sold to another bank. But there was a program then that the Bank of Commerce, the New York City Bank, would be sold. The investors were left in the posture, in effect, of starting a new bank. When we were going through the regulatory proceedings before the Federal Reserve, this was, of course, completely unforeseen. We didn't anticipate that we wouldn't acquire the bank in New York City. And the condition that was agreed to with the banking board in New York was that if the Bank of Commerce were sold, a license would be granted for the little Albany bank that remained in New York to open in New York City, to gain a license to branch into New York City, and it shifted its headquarters to New York City. When the acquisition was completed in the spring of 1982, we were then in a very awkward and to some extent unhappy posture. We were under an obligation to sell the New York City Bank, and we were under a need to set up a new bank and really set it up from scratch. We had nothing in the city. We had no staff. We had no location. We had no resources. It put us in an obligation to sell the New York City Bank, and we were under a need to set up a new bank and really set it up from scratch. We had nothing in the city. We had no staff. We had no location. We had no resources. It put us, as I say, in a difficult position. Now, throughout the takeover litigation and during the regulatory proceedings, we essentially had two contacts in New York. One was the law firm of Wachtell, Lipton, Rosen, and Katz that was co-counsel with us and represented the shareholders during these proceedings. and the other was BCCI, which had a representative office and was acting as the investment advisor. And we used those resources to try to get set up in New York. Our first obligation was to try to find space so that we could open the bank in New York. And there was some urgency about doing that because we were under pressure to sell the Bank of Commerce, and we didn't want to sell that bank until we had been granted the right officially to open the new bank, and that required us to have space that was leased. And so we went to the people we knew at Wachtell Lipton, and we asked the attorneys, did they know of space in the city? And they did, and they recommended space. And we went to BCCI's representative office in New York, which was then headed by this man, Ellie. And he also attempted to assist us by telling us of brokers or space that he was aware of. And indeed, this was something that I worked on personally, but I was not in New York City, and when I would go up there and I was to get back messages or information, I would usually ask people to send it either to BCCI in New York or to the New York lawyers. They acted, in effect, as a local contact for us. And so BCCI was trying to be helpful to us. Now, this did not seem particularly out of the ordinary. BCCI had recommended this investment to these important clients, and an investment advisor certainly wants the investment to be successful. That's how you remain the investment advisor. And so this may be a long answer, but I think you have to understand the context. What I am assuming happened is that Mr. Ellie is reporting on what he has been doing to his superiors in London, and he reports that he has given us some information on space that we might acquire.
Well, was it limited to space? I mean, was this all that BCCI was doing?
No, BCCI generally tried to help us get established in New York.
Okay, now, this occurs very shortly after the whole go-around with the permission of the takeover, correct?
Sure.
And Muckenfuss had accepted that based on the representation of the letter earlier, leaving out the in the future, leaving out the financial transactions themselves. The management and affairs were supposed to be separate. I mean, it seems to me that you began almost immediately the very thing that they had feared, which was an interrelationship, a financial dependency, a sort of intermingling of the affairs.
Senator, if I might, I don't think that's the way I would characterize it.
Well, let me ask a few more questions about
Sure.
it then, and then see.
Okay.
3 months later, directing yourself to the next document, there is a letter to Mr. Naqvi. Now, you have testified that Mr. Abadi was your communications link, and Mr. Abadi was the advisor for the group. Here is a letter to Mr. Naqvi on Bank of Credit and Commerce stationery by Mr. Ellie. A meeting was held between myself and Mr. Altman in New York, at which the following subjects were covered: not only the subletting of space, but selection of board directors, recruitment of key staff, selection of auditors, selections of lawyers, compensation package including fringe benefits, projections for first year's operations, coordination with holding company and shareholders. Now, these are some of the most important decisions that a new bank would make. And here is Mr. Ellie reporting to Mr. Naqvi at BCCI on this transaction. Why is that not directly in contravention of what Mr. Muckenfuss was talking about?
The understanding that we had with the regulatory authorities was that BCCI was not going to make the decisions, that control over the operation would remain with Mr. Clifford and the board of directors.
Isn't
Now-
that, I'm sorry to interrupt you there, Mr. Altman, but
Yes,
isn't
sir.
that kind of a nicety? I mean, aren't we really talking about differences without a distinction, distinctions that aren't a difference? I mean,
No.
here you are sitting, they're reporting to Mr. Nakvi, you're talking with him about the recruitment of board directors, et cetera, and it's Mr. Ellie reporting. It's not you reporting. You're the lawyers. You're supposed to have the communications link with Mr. Abadi.
Senator, if I might, a couple of points. The first is that while Mr. Abadi was the individual who had the close personal relationships, for the most part, with these Middle Eastern investors, it wasn't Mr. Abadi personally who was designated as the communications link. It was BCCI, the institution. And Mr. Nakvi was his right-hand man who later succeeded him. So,
Seems to me that makes it even more complicated. If BCCI as the bank is the entity and not Abadi, you've got a real problem here in terms of dealing with the separateness.
well, I'm trying to explain what the understandings were. It was understood by the regulatory authorities at the time, not that Mr. Abadi was the advisor to the shareholders, not that Mr. Abadi was the communications link, but that BCCI performed and would continue to perform those functions. That was expressly disclosed to the regulators during the regulatory proceedings in 1980. In 1981, I could refer you again
But wasn't
to...
it expressly objected to by them afterwards?
No, sir.
That's not what this letter means?
Well, you're not talking about Mr. Ryback's letter. Are you talking
No,
about the
I'm
letter
talking-
that Mr. Muckenfoos wrote?
Yeah.
Mr. Muckenfoos was writing an opinion for the controller of the currency to the Federal Reserve, giving the Federal Reserve their comments on the application. They were not the decision maker.
I understand.
The Federal Reserve and indeed the controller understood that we were going to have a continuing relationship with BCCI. It was stated expressly in the application. It was stated at the hearing. Some of the hearing examiners made that comment that they recognized that BCCI was going to continue to provide this service. This was not anything that was unknown to them, but the basic understanding was that the control over First American was going to be exercised by the American board, and I refer you again to the comments made by Mr. Clifford in his opening remarks. They have now come in and done intensive audits of First American. They did them all through the years, and when this allegation arose, they came in with this wide-ranging, intensive, coordinated audit of the holding company and all the banks, and the conclusion that has been reached insofar as it has been reported is they find no evidence of any BCCI control over First American, and that is the issue.
Well, control is a fascinating issue here. You're absolutely correct. There are many definitions of it: actual, constructive, legal, so forth. And there is such a thing as hidden control. I mean, that's another nature of the beast, where you can have all kinds of things happening on one side, and then there can be real control that is not even hidden, that is not exercised, neither constructive nor implemented, but it can exist, to be exercised at some appropriate moment. So control is a very big question that's sort of dangling out there, and I don't think anybody has a handle on it yet. But proceeding just to sort of go through these various things that sort of go to this issue of control or of what is at stake here, and this is really just part of the confusion. I mean, I don't know what it all means. I just know that it raises a question and that you can't help but ask it. And for instance, turning to the next document, you have Mr. Nakvi again receiving a letter from Mr. Ellie in which Mr. Ellie says, Ray, the Board of Directors, First American Bank. He says, I am enclosing for you the particulars of an individual who I've known for the last 4 or 5 years and who I consider to be eminently suitable to be a member of the Board of Directors of the First American Bank of New York. Mr. Richard Paget is president of a very prestigious management consulting firm. He's on the board of a number of companies, including the Washington Post. My relationship with him are fairly close, and I feel we could not only use his name, but also his contacts, which are at very high levels. Mr. Paget's 69 years old. Recently, he's been awarded the U.S. Navy Civilian Service Medal and has agreed to become chairman of the American Friends of the Australian National Gallery Foundation. I would like you and Mr. Abadi to meet him on your next visit. Yours truly, Caruso Karamat Eli. Now, here you have Mr. Eli, who works for BCCI, writing a letter to Mr. Naqvi, Ray, the board of directors of your bank, and he says, I am enclosing who I've known, who I consider to be, who I feel, I would like you to meet him on your next visit. There is no mention of Mr. Clifford or Mr. Altman. There's no mention of CCAH. This seems to be a totally sort of BCCI operation with respect to the board of directors of your bank.
Senator, I have several comments to make because I think they're indicated. As I stated initially, we had a very unusual situation that developed in New York, and you are focusing on a period nearly 10 years ago, very limited in time, and it's appropriate that the committee look at it. But fairly, the committee should look at what happened at First American for the decade that we managed this property in New York and in Washington and in Maryland and in Virginia and in Tennessee and in Georgia and Florida and all of the various subsidiaries we have. And I think that you will conclude that there was no control over First American by BCCI. I give you two quick common sense indications of that. One, there is a perception that BCCI is a corrupt institution and that it engaged in misdeeds around the world. Now, if BCCI was controlling First American for 10 years, presumably you would find some indication of that, but you do not.
In what sense? What do you mean by that? I mean, when you say
BCCI, if you accept the allegations, I don't know whether they're true, but accepting them for purposes of discussion, that BCCI engaged in everything from financing terrorists to money laundering and all this parade of horribles, account manipulations, fraudulent statements, cheating depositors, etc.
I don't think that happened in First American, and I don't think anybody's suggested that.
Well, I'm making two basic points.
Yeah.
Point number one is the evidence is I think quite clear that First American was operated honestly. And if we were controlled, to the best of my knowledge, and I say the best of my knowledge, I absolutely agree with the basic premise that the bank, as we knew it in Virginia, Maryland, Washington, you know, I haven't discovered any impropriety in the day-to-day operations. But you see, that's sort of skirting the issue, I think, and I'm just trying to put in front of you what the issue is that keeps coming back. The issue is, did Mr. Abadi set out on a quest, which according to the testimony of countless people now, Mr. Rahman, Mr. Sakia, people who were part of this bank, have talked about his goal of entering the United States market, of gaining a foothold in America. And he tried several times in several places. Everybody knows he wanted to do this. It's part of the regulatory record. There's no mystery. He wanted to be in the American market. And he couldn't do it with an outright purchase initially because Bank of America was there. And then there were some problems in what they were able to disclose, and they didn't want to come under one regulatory head at first. So they found their shareholders, maybe without you even knowing it, obviously. You've so testified, and nobody's shown to the contrary. He comes up with this investment group, puts them in as First American,
And First American now has a group of shareholders from the Middle East run through Mr. Abadi, who very cleverly is managing this group from the Middle East, getting a foothold in America, and you are representing it very effectively and competently. You're wearing a lot of hats. You're attorneys for BCCI, attorneys for him, attorneys for the bank, president, manager of the bank. It's very tight. So nobody knows really, you know, whether 10 years from then he expected to cash in, maybe buy you out, have a foothold, have built it up. But that's the issue that's lurking here, is sort of what was going on. Now, I'm willing to allow, let's say we leave the New York situation for a moment. You say that that is a situation that was set up because you had an urgent need to deal with the New York bank.
But I'm not saying that anything inappropriate was done despite the urgency of the situation. I'm just trying to describe for you what happened, and I
accept that. I just want to move on from that then, accepting that. You've said that it was a legitimate sort of relationship that you noticed the Fed would continue, and this was an urgent situation, so they were helping you in the context of the urgent situation.
But they were not,
fair?
yes, sir, but they were not making the decisions.
Okay.
The decisions remained with the American group, as we had said to the Federal Reserve. If I could just complete the thought that I had a few moments ago.
Sure, absolutely.
Complete the thoughts that I had. One, I say that we prove the negative. Did BCCI control you? We say, no, they did not. We point to the evidence that if BCCI is a criminal organization, as has been alleged, why, from a common sense standpoint, do you find no indication of that at First American? Why are there none of the practices at First American that are said to be in other parts of the BCCI operation if we are really a part of BCCI? That's point one.
You want me to answer that?
Certainly.
Because it is, I mean, I can give you an answer. I don't know if this is the real answer, but because it obviously didn't serve their interests. They didn't have the kind of data, sort of, they had conceivably sort of expectancy control and expectancy ownership through their knowledge of the shares they held because of the financing mechanism. But indeed, they wanted you out there, out front, controlling and growing and moving on the day-to-day decisions, because ultimately they wanted an asset that was a big asset that had grown, and they didn't want to upset the American marketplace. There's ample evidence that they continually sought ways to avoid coming under the United States regulatory process, precisely because they would then not have had the freedom they had in the Cayman Islands, Panama, and other places to do the kinds of things that they were doing. So, I mean, that's, I think, the answer to your statement.
Senator, I've refrained from interrupting because as Mr. Altman and I started together, and as we have continued through the last 9 years, we would separate the areas of responsibility. New York was one of his areas of responsibility, so I have not interfered. You cannot look at any of these comments without understanding that the relationship and agreement between Mr. Abadi and me was such a final and definite and unequivocal one. I told you about the understanding when I first agreed to take over the chairmanship. The agreement was that I would have total responsibility and I would have total authority. He never violated that at any time. He can make suggestions, he can make offers of help, but when this time came to make decisions, he didn't make any one of these decisions in any way. The board and I made them all. Now, we turned for help in New York to BCCI because we needed the help of a banking organization that had a background in foreign banking. Mr. Altman and I had no background in foreign banking. Keep in mind, New York was just one of our 8 banks, and I think constitutes maybe 15% of the assets of First American. So it was not by any manner of means our most important. It offered the most serious problems because we had to start a bank from scratch. Literally, we bought chairs and tables and typewriters and pencils and erasers. We started right from the beginning. We needed the help we could get. We turned to Wachtell Lipton for help. We turned to 2 or 3 banking advisory groups for help. We turned to Abadi and his organization for help. And by all working together, we got the bank started. But all during that time, they were assisting us. They did not make one decision.
Is it possible, Mr. Secretary, that Mr. Abadi and the group around him were convinced that they owned First American and they didn't need to make decisions, but that they viewed it as part of their holdings without your being aware? Is that what you're, I mean, is that...
You ask, is something possible? It never entered our mind at the time because we never had the slightest indication that BCCI owned any stock in First American or even contemplated ever owning any stock. We accepted them in their capacity as representative of the investors who were our bosses.
Well, didn't there come a time when one of you saw a printed brochure of BCCI with First American in it, and you discussed that with Mr. Abadi? Do you recall that incident?
No, I do not.
I don't either.
Let me direct your attention to document number 12, which are the minutes of a U.S. marketing meeting held on April 24th in New York. The following attended the meeting: Mr. Ijaz Afridi, Mr. Tariq Jamil, Mr. Caruso Karmat Eli, and then 7 other people are listed. The 7 other people are all employees of BCCI, but at that point in time, Mr. Eli represented First American in New York. Mr. Tariq Jamil was running National Bank of Georgia, a bank that they don't own yet, but which has the BCCI logo. And Mr. Afridi is representing, I believe, First American. So here you have a minutes of a U.S. marketing meeting held in 1985, and I read from the matters discussed, purpose of the meeting. Mr. Afridi opened the meeting and emphasized that the purpose of the meeting was to coordinate the efforts of different locations of BCC and other institutions so that the President's desire to have a totality in approach is achieved. It is a great challenge that the group faces in the present and future U.S. operations, and this is only by the joint efforts and coordination we could meet the challenge. Mr. Tariq Jamil described it as a very timely meeting. Now, this is the National Bank of Georgia talking at a U.S. marketing meeting for BCCI, National Bank of Georgia being owned supposedly by Gaith Ferrone with a loan from BCCI. And they describe it as the first meeting as the initiation of our efforts to move into the future of BCC and USA in a calculated and planned way with the uniformity of approach and totality in operational objectives. It talks about the assistance of U.S. operations will be presented to the CSO. I gather that's Mr. Abadi. Now, it goes on, and Mr. Afridi of First American says that our major task in the U.S. should be to build market share. BCC had been a success. Now, this is Mr. Afridi, then working, I believe, for First American, talking about BCC having been a success in Third World, and now we're embarking on establishing an equally successful business in the most competitive country in the world. He requested the members to work together to overwhelm the U.S. market. Historically, we have not made calculated approach to the local indigenous market, indicating that now they will. I mean, as you read this, and here's Mr. Sakia, who testified here the other day, Mr. Sakia talking about concentrating on increasing the customer deposit base and so forth. Finally, the National Bank of Georgia, to update each member of the operations of different units, they would discuss their size and volume. So here you have the National Bank of Georgia, not yet purchased by you, then owned supposedly by Gaith Ferrone on this loan from BCCI, and all of these banks are here sitting there together talking about their size, their customer approach, creating a 1985 coordinated approach to this process. And obviously one is left looking at this with an extraordinary impression of a very special relationship that existed here, unlike other banking institutions that are competitors or that are separate or that are operating according to the standards that I thought the Fed expected. Now, I guess you're going to say that's not what it meant, but can you explain to us what it does mean?
Senator, I cannot explain what this does mean. To the best of my recollection, the first I heard about this committee was in the fall of 1990. I received a telephone call from a reporter from the Washington Post, and he had asked Mr. Clifford and me about an American coordinating committee. And I have not had the opportunity to study the minutes of those various meetings, so I can't comment on what was intended, and I can't comment on the propriety of what the participants were doing. But I think it is troubling. But these are matters, to the best of my recollection, we never heard about until these documents surfaced.
Is it possible, Mr. Altman, then, that Mr. Ellie and Mr. Afridi were working for you but behind your back? Unbeknownst to you at these meetings? Did you not know they were at these meetings?
That is correct.
Now, Mr. Ellie says at the end of in this conclusion, he says, this is on page 7, he says, Mr. Ellie concluded that in America, we are sitting on $7 billion of assets, and this is just the beginning. The U.S. team should play an important role in identifying the products in the market and so forth. There's no way they could obviously talk about $7 billion in assets without including the First American Family and National Bank of Georgia in there. And in fact, Mr. Sakia and Mr. Rahman both assert that's exactly what they did. So you're saying that these folks were basically somehow viewing themselves as a separate entity, acting as that, but absolutely without your knowledge?
To the best of my recollection, Senator, we never heard about any of this activity. Now, I would say there is nothing necessarily impermissible on banks getting together and talking about business, but the way this is presented here is disturbing. But this is, I understand that the minutes of these meetings show, and I haven't seen them all, but the minutes of these meetings show that neither Mr. Clifford nor I ever attended any of these meetings or were given copies of these minutes. I think it appropriate to note that these two individuals from First American were working for First American Bank of New York. And whatever efforts they were engaged in here, they would have to answer. I could not explain, and certainly I'd need some time to study the documents, but I think it appropriate to have in the record that the chief executive officer of the bank, a man named William Duncan, he's been the CEO there for about 6 years, this past year wrote a letter to customers, employees, and friends when the financial statements came out. It's dated March of '91. And he writes as follows. As this report goes to press, there has been publicity concerning First American Bankshares, this bank's holding company, and the Bank of Credit and Commerce International. The publicity addressed alleged connections between BCCI and the management of First American Bankshares. The sensationalized tone of some of the publicity was disappointing because First American Bank of New York's integrity has always been of the utmost importance to me personally. I'm quoting, "At no time did the Bank of Credit and Commerce International exercise any control over the management of First American Bank of New York. This bank is independently governed by a board of directors comprised of distinguished business people as well as a group of highly professional managers who use their objective judgment and experience to guide our organization." And he describes this, a little bit of the board. So I can't explain what was going on at these meetings, but I can tell you what the perspective was from the senior officers in the company.
Let me, I have some more questions along this line, but let me turn to Senator Brown for a moment here.
We had earlier heard from Mr. Sakia, who you may have heard that testimony, perhaps not. But there was a point in his testimony where he indicated that he had helped coordinated marketing for BCCI in Canada and the United States, and implied clearly that that he in effect had developed marketing plans, market allocations for BCCI's holdings in the North American continent, and directly implied that that the operating nature of these banks was that they all operated as though they were directed by CCI. In effect, he indicated that First American operated as a branch in this regard. Can you think of anything? Well, first of all, would you comment on that? And
There is much that Mr. Sakia has said to which we take the strongest exception. It is false and it is without factual foundation.
well, that's a very direct statement, and I think deals with that. Is there anything you can recall in terms of meetings that would have given him this impression?
Let me try, Senator, what impression? I just give them that again. I didn't quite understand it.
The impression that that BCCI coordinated your marketing strategy
Of our various banks?
Mm-hmm.
Totally untrue. Let me say that the background of this whole subject is such that we never knew these meetings were going on among the BCCI people. It may be during this period. We don't know when they began to acquire First American stock. We didn't know that. Nobody else knew it. So they had plans going on, secret plans. Perhaps they were conspiring among themselves. But we weren't conscious of that. The authorities weren't conscious of it. This may be part of the typical operation of the way BCCI does its business, handling it secretly. This was probably going on, using the analogy this morning of an inside bank and an outside bank. This is the inside bank operating. As long as you have brought up, Senator, the name of Mr. Sakia, I was so concerned about a comment that he made yesterday that I decided to put my remarks in writing so that perhaps they'd be restrained. If I made them naturally, they'd be less than restrained. I hesitate to dignify Mr. Sakya's testimony by even referring to it. But I want this committee to know that at no time did I ever say to Mr. Sakya or anyone else in a joking manner or otherwise that we can, quote, now tell more lies. It was an outrageous statement, has no basis whatsoever in fact. It's totally a departure from any kind of comment that I would make. It's grotesque, it's totally and categorically false, and I think it's exceedingly unfortunate that such a remark was made and spread out to the public that I'm talking to somebody else about the time has come to tell lies. And I deeply resent the opportunity that he had to tell that.
Well, let me just say, Mr. Clifford, I hope, I don't know if you knew, I reacted to it with a certain amount of shock at the time, and I questioned it 2 or 3 times because I did think it sounded bizarre. But it was something that he insisted on saying and wanted to say no matter what, and as incredulous as I thought it sounded, no matter for anybody to make, he insisted on making it, and I think we went back over it several times because I think we were both somewhat dumbstruck by it. But anyway, be that as it may, Senator Brown.
Well, along this line, there was a memo dated September 4th, 1984, from this Mr. Naqvi, and I don't know if you've had a copy of that available to you.
I don't have it, sir.
I'd like, I guess we have a copy we'll bring down to you. I was hoping when you've had a chance to review it that you would, might be willing to comment on it.
We've seen this before.
All right.
Senator, we had not seen this before. My recollection is that it first came to our attention when we were testifying before the Federal Reserve. I remember the incident about which Mr. Naqvi is speaking. We wanted to keep Abedi and Naqvi informed so they could keep their investors informed. We were selecting from time to time directors. We went ahead and did it on our own in about 95% of the instances. In this one, here was a man, a very able fellow that we were considering bringing onto the board, Pursley. But he was a partner in J.H. Whitney and Company. Now, we wanted to be sure that that didn't constitute any kind of a conflict in the operation of our banks. And in the event that we just wanted to be careful, we mentioned that to him. We didn't have to be guided. My recollection is that they said they had no objection to Mr. Pursley, but later on, as a result of other developments, we did not appoint him. There's something that's fundamental, and that is, in every contact we had with BCCI, after our understanding on what we'll call responsibility and control, and that meeting in London, everything that passed between Naqvi and Abedi and me was in contemplation of that agreement that we had. If they had suggestions, we would be glad to hear them. Sometime we even asked them for their reaction to something. But in the last analysis, the board and I made every decision without any one exception.
The paragraph I wanted to draw your attention to was at the end of number 1. It reads as follows. I indicated to him that if Mr. Clifford's judgment is that he would be suitable for the proposed position, Mr. Abadi should not have any reservations. To save time, I suggested that he may proceed to finalize the arrangements. The implication being, and I guess I would appreciate your view as to whether you feel it's a fair implication, but the implication being that Mr. Abadi would be required to pass on this before action could be taken, or there was a relationship that involved Mr. Abadi passing on this. Would that be a fair reading of this, or have I?
Well, I can only read it in the light of what our understanding was. We had said, we're considering this man, did they have any reactions of any kind? We get whatever their reaction was back, and then I made the decision.
The reaction you were looking for was from someone who is an advisor to you, not someone that you viewed as, or the reaction you're looking for is someone who is an investor?
No, we treat Mr. Abadi, we treat Mr. Naqvi as the representative of our investors. And maybe we felt that it was an important enough matter, we might have gone to the investors, but we didn't. That takes too long. We wanted to get any reaction that they had. We would merely put that in our computer along with other information before the board and I made the decision. That's what it comes down to.
Senator, there is, I think, a much more fundamental, I believe there is a more fundamental event that might throw light on this issue that you are pursuing. In this case, Mr. Clifford ultimately did not determine to put Mr. Persley on the board, so this didn't go anywhere. And obviously, we can't speak as to what the author of this document had in mind or interpreted Mr. Clifford to be saying. We had not seen it before. But let me reference you, if I might, to the acquisition that First American made of the National Bank of Georgia. I think, again, we're in the posture of proving negatives continually, but I think this is a transaction which is quite revealing. National Bank of Georgia, we understood to be owned by Gaith Ferrone, and while it was under his ownership, it operated in a manner that was quite characteristic of BCCI. I don't know if BCCI actually controlled it or if they just adopted BCCI's operating characteristics, but it was very similar to a BCCI operation. And I was making the point earlier that we have operated very differently than BCCI despite allegations of control. And the similarities between the National Bank of Georgia, when owned by Dr. Ferrone, ostensibly owned by him, and again, we don't know the truth as to that allegation, but that bank at the time, it was acquired by Dr. Ferrone, changed the way it had operated. And it started to operate the way BCCI operated in the rest of the world. That bank had been a retail-oriented bank. It totally changed its focus, and it became, or attempted to become, an international bank doing trade financing and the like, such as BCCI conducted in its operations in the rest of the world. They adopted cultural characteristics of BCCI. They changed their logo so that it was very reminiscent of the distinct logo of BCCI. They changed the way their executives sat on the floor of the bank. Instead of being in offices, they were all out on the floor. This was a BCCI concept. Indeed, we understand they distributed BCCI literature. A man from BCCI went to the National Bank of Georgia, this Mr. Jamil, who the chairman made reference to earlier, and became, I think, the chief operating officer. He was running the bank. A Mr. Carlson, who had a close association for many years with Mr. Abadi, became the chairman of the bank. That was the situation when we acquired the property in the summer of 1987. And I think it appropriate to look at what happened to that bank after we acquired it. Mr. Carlson, the chairman, presumably if BCCI owned it, was someone that they thought was an appropriate chairman of the bank. Mr. Jamil, if BCCI owned it or controlled it, at least it operated in a manner characteristic of BCCI. We replaced Mr. Carlson immediately. Mr. Jamil departed. Another individual who was close to Dr. Ferrone also left. We installed as the chief executive officer a man named Mr. Freeman. Mr. Freeman is a man who, in point of fact, was not much taken with BCCI. He didn't find much favor with the way they operated or their corporate cultural concepts. But despite that, because we thought he was the right man for the job, even though he didn't have particular regard for BCCI, he was installed as the CEO of that bank. Whatever BCCI may have thought of him or he thought of BCCI did not enter into it. In addition, we changed the strategic concepts at the National Bank of Georgia. We de-emphasized this international focus that they had had. We returned to the way that First American operated, which is a primary focus on retail banking and on banking with small commercial businesses. We got rid of the cultural concepts. We put them back in offices. We eliminated the distribution of BCCI literature. We operated it as a First American bank, just like all the other First American banks, and that's what we did for 9 years. And I return to the conclusion that the Federal Reserve made this year, having heard all these allegations and come in with a coordinated audit of First American involving the FDIC, state regulatory authorities, the most experienced federal examiners they had from all 12 Federal Reserve districts. They wanted their best people, and they went through First American, and they went through everything at First American. And their conclusion was, and in delving into these records, we've found no evidence of influence or control. That was the conclusion of the Federal Reserve, and I think the experience at the National Bank of Georgia is indicative of that.
Well, that is responsive.
I need to interrupt at this point because we're on the back end of the vote that typically was predicted for earlier than this. But if you'll forgive us, we're going to recess just for the period of these votes. I suspect it would be a recess of 20 minutes or so, and then we'll return. We stand at recess.
Thank you, Senator.
The hearing will come back to order. Thank you all very much for your patience. I apologize for the interruption. I think we're on a clear course now, and we ought to be able to proceed until we finish, which I hope can be punctually, and obviously we'll try to do that.
Thank you.
Let me come back. Did you complete your line of questions, Senator Brown?
If it's timely, Mr. Chairman, I have a few other lines, but I think it makes sense to go ahead with yours. But I would like to put some things in the record now, if the subcommittee might consider. There's a statement here from Senator Helms on the subject that he would like entered in the record.
Without objection, so ordered.
Several questions that Senator Helms would ask to be put in the record and ask for responses from the
Without objection, we will leave the record open in the event that we have some questions, or in the event that either of the witnesses would like to submit something subsequently. So the record will remain open for a period of time, about a week or so.
Thank you.
In addition, I have two other things that I would hope we could include. One is a three-page analysis from tax notes, the October 7th edition, dealing with a question with regard to compensation, and specifically an area that we had discussed earlier today.
Without objection, so ordered.
And Last, I thought you raised an appropriate point with regard to the White House staff and statement put out by the White House in that regard. I thought made sense to include in the record as well.
Without objection, so ordered.
Thank you, Mr. Chairman.
Indeed. Gentlemen, there are, I think, two principal areas that I want to try to make some inquiries about, and then I'm going to try to see if we can move on. There are a few sort of loose odds and ends also that I just want to try to touch on in a few places. Coming back to the question of sort of the nature of the involvement, and let me just say that I think, Mr. Altman, your statement about the changes that were made in the bank, I accept, and I think the committee accepts that indeed those were made. The concern the committee had was that that happened in the wake of the 1988 drug money laundering indictment, when chills and alarm bells went off in BCCI. And what witnesses have told us, and the reason I ask this is not some sort of grand conspiracy theory that we're conjuring up. I assure you we're trying to separate what's sort of grand and outrageous from what's reality. But a number of witnesses have testified under oath and put evidence before the committee to the effect that what you really had happen was in 1988 with the drug money laundering indictment, concerns were expressed in London and elsewhere about the exposure of the bank overall as a consequence, and whether or not that might draw the regulators like moths to the Klieg lights, or politicians. And, and the result was that there was sort of a get the act cleaned up, not necessarily in First American, because frankly I don't think First American as a banking entity had those kinds of problems or had a need to get something cleaned up, but that outside of it, and particularly with respect to NBG, National Bank of Georgia, and the Gaith Ferrone situation, coupled with his financial problems, which put the bank at exposure, it has been asserted by Mr. Sakia, by Mr. Rahman, and others, that it was necessary to dump the bank and protect it. Now, do you have any comment on that?
Senator, I'm puzzled. The National Bank of Georgia acquisition was completed in the summer of 1987, and these changes were effected immediately upon acquisition. This management change that I've described and others were affected immediately. BCCI was not indicted until October of 1988, a year and 3 or 4 months, 12, 13, 15 months later. So I don't understand the point. I'm confused.
Let me come back to that, and I'll try to tie it together in the context.
Okay.
But the other pieces that have been brought to the committee's attention, again by the witnesses who have testified, as well as by the Fed and others who've provided both documentation and information, is the ongoing sort of business relationship as it appeared to some. For instance, turning your attention to document 13, there's a telex message that shows Mr. Sakia had arranged for First American New York to get a deposit of $4,200,000 for 6 months at slightly below market rates. That was sent to you, Mr. Altman, in Washington. Then the next document shows in paragraph 2 of the enumerated paragraphs, all business passed on by BCC to First American Bank, New York, may please be reported to Mr. Afridi. And so you had a sort of joint management relationship which people have alluded to. Then the next document, this was the coordinating committee which you referred that you hadn't heard of. There are other documents, and again, I'm not going to go through each and every one of them here because I don't think it's the moment or time provides for it. But there was this ongoing, very integrated exchange of deposits, of of business, if you will. And Mr. Sakia told the committee that from their point of view, they didn't mind taking a loss, or they didn't mind putting the business there, because to them, it was viewed as their business. They were going to get it through the relationship of First American to BCCI. Now, that's what they say. I think you heard that testimony. So
I've heard a part of Mr. Sakia's testimony, and the committee can accept it for whatever weight you wish to give it. I've stated earlier, I take the strongest exception to many of the statements Mr. Sakia has made, not just the one that Mr. Clifford has identified, although I think that's indicative of that testimony.
Could I ask you, Mr. Altman, as an attorney as well as a participant in this, what motive you would attribute at this point to Mr. Sakia with respect to his testimony? I mean, is there something that you've thought of? Is there a sense you have of what's happening here?
There is, Senator. I'm not sure that this is what you want me to go into in public session, but if you do, I can.
I'm looking at Mr. Bennett, who feels that it would be more advisable not to at this point.
Senator, yes, I think in fairness to use the committee, Senator, there are certain matters that are under seal in federal court, and while as much as I would like Mr. Altman to answer, I don't think it would be appropriate for him, nor would it be in the interest of this committee.
There are some other matters that are privileged, and I want to be careful about making commentary which is not perhaps commentary that should be offered in public, but there's certain information that we can provide the committee, I think, that might be illuminating.
May I ask you at this point in time then, at least in open session, were you ever contacted, either of you, by members of the intelligence community of the United States government?
I have not been.
Nor I.
Either of you. Do you know whether or not Mr. Abadi was?
I do not know.
Nor I, sir.
Was there?
I did not ever hear him say that he had been.
And was there any time in the course of any discussions with you when he alleged in any way that he was concerned about the CIA or about being on the watch list or any such matter?
Never in my presence.
Never in mine.
And you never heard from any of the personnel within the BCCI community anything to that effect?
I did not.
First I heard about it was some reference Mr. Sakia made in his testimony, to the best of my recollection.
Do you, at this point, have any knowledge with respect to the $10 million Adnan Khashoggi note through BCCI?
I don't know anything about it.
I do not. I'd never heard of it.
Was First American in any way used as a depository of intelligence community accounts?
Senator, I don't have the specifics about it, but I do have an understanding that the CIA has maintained accounts at First American.
But you have no knowledge of any of the reasons therefore, or the specific efforts that those accounts might have been part of or anything?
No, I do not.
None whatsoever. With respect to another area of inquiry with respect to BCCI, did you ever become aware in your dealings with National Bank of Georgia or with Mr. Gaith-Farone of any involvement that he might have had or that the bank had with SunTrust in Florida? Did you ever learn?
I heard that, best of my recollection, after he sold the National Bank of Georgia, he bought a large stake in SunTrust. I think he was the largest individual shareholder. I think that's what I was told.
Do you know when that would have been?
Well, our transaction was completed in '87, so probably around that time period. But I wasn't involved in it. It's just something I had heard.
So you have no firsthand knowledge as to any BCCI involvement specifically with SunTrust?
Well, that's a different question. There is an investigation that was commenced, if I recall, it was with reference to a debenture or some issue that SunTrust got out, that either BCCI or Dr. Ferrone or both of them participated in a $25 million debenture. There's some allegation about that. I don't know the specifics of it, but I'm aware of it.
But it's only through the investigation that you've learned anything about
Oh,
it?
yeah, I didn't know about it
You knew
before all
nothing
this
about it
arose.
from
I wasn't
firsthand
involved in
knowledge.
that,
All
no,
right.
sir.
No, that's just, I just wanted to find out whether you were or not. Let me come back now again to this question of who knew what, and I think it's very helpful to us as we've been proceeding to get a sense of where you stand with respect to what you understood was happening at the time and what others might have understood. Because some of the evidence that we have is obviously suggestive of something else, and one needs to know what it means. And I turn your attention, again, going back to this question of the mutuality of relationship, to document 14. Document 14 is a minutes of the President Abadi's meeting with the Far East region, senior executives in Hong Kong, in April of 1987. And what he says there, this is a sort of transcript of his comments or excerpt of them. And he says, "For me, this is the event in importance only to one event that happened in September 1972 when this bank came into being. If I were to be honest with you, I think it's not second to that, but it's just as important to that. This bank," referring to BCCI, "has become a significant banking institution in the Committee of Banks internationally. You are now," speaking to all the assembled personnel there, "you are now with the First American group of banks. At the moment, over 27 billion in assets, and we will be 30 billion by the end of this year. We are now being recognized in the Brotherhood of International Banks as an important factor to the banking system of the world." At this meeting was Mr. Tariq Jamil from National Bank of Georgia, or formerly therefrom, and other members of the BCCI First American community. Were you there, either of you, at that? Is this a document you've ever seen?
Best of my recollection, the first time we saw this was last night,
When we provided it to you?
when you provided it to us.
Does it indicate to you, as it seemed to us, that Mr. Abadi is certainly not keeping a secret of the fact that he thinks he owns First American, that it's part of the family? And would you agree, at least with that as his assertion?
I'd have to add that I do not understand, Senator, when he says, "But you are now with the First American group of banks, at the moment over 27 billion in assets." That's not us.
Well,
I don't know what he means.
You had how much in assets? 11 billion.
The highest we ever got was 11.5 billion.
Right. Well, he's adding in all the 69 branches of BCCI. What he's saying is that the BCCI family, including First American, now represents $30 billion worth of banking power.
Well, that doesn't add up either, because by 1987, I would say that the assets of BCCI must have been $20 billion.
Is that according to Price Waterhouse, or? We'll figure that one out. I suspect it was a fluctuating total asset base, but who knows? So at any rate, this is a mystery, is that correct?
It's a mystery to me.
It is to me. Obviously, we had some shareholders in common, but I can't explain this language.
Does it not strike you as extraordinary that in 1987, so publicly, they are marketing? I mean, surely you would understand why Mr. Sakia would come here and say, it was no secret we owned First American. I mean, this seems to give some credibility to the notion that he had a reason to believe he thought that they owned it.
Senator, it was a secret to the Bank of England, and it was a secret to Price Waterhouse, and it was a secret to us, it was a secret to the Fed. So there were a great many people.
Actually, Mr. Secretary, and I don't want to, I'm not here to just as I contradict you, but it wasn't a secret to the CIA in 1982 because they moved a memo through the agencies of government saying First American has bought, BCCI has bought the banks in the United States. Did you read that memo?
We would give a great deal if only we could have been told about that memorandum in 1982.
I'm sure you would.
Yeah.
I have no question about it. Let me move on to the next document, if I can, Mr. Altman. It's number 15. This was a deposition taken with respect to the Virginia Bankshares case in 1988, and in it you were asked on page 17 of the memo, it's the second page of the three-page memo, you were asked about your communication with the investors of CCAH, and you were asked, is there any particular investor with whom you communicate on a regular basis as opposed to other investors? You said no. Do you communicate with all of them with equal frequency? You said no. Is there an investor with whom you communicate with greater frequency than with others? You said no, there's no particular pattern to it. Sometimes some of the investors call me, or at times I will contact one of them. At times I will contact all of them. Do you recall that testimony?
I don't recall specifically this testimony, but I accept what the transcript says.
The reason I ask you that is because one of the questions raised in the House and one of the questions raised publicly is sort of how often these investors appeared and really were dealt with and so forth. And if you turn to the next document, which is a First American Bankshares document 16, a letter to Mr. Foulage, it is a notice from Secretary Clifford to the shareholders about an important meeting, about a meeting to discuss important developments at First American Bankshares. And the meeting was to be held in London on October 23rd, 1990. Was that the, well, strike that. The question I ask is turning to the next document, number 17. You invited in your letter each shareholder to designate a representative to attend on their behalf if they couldn't attend. A representative did attend, representing the government of Abu Dhabi, Sheikh bin Sultan Al Nahyan Zayed. And his report to Sheikh Zayed said as follows: the meeting was attended by Mr. Clark Clifford and Robert Altman from First American. The shareholders or their representatives present were K.E. Kamal Adham, Mr. Guhari, Mr. Foulage, and myself. The meeting was opened by Mr. Clifford, who gave a background of First American and its progress to date. It was pointed out by Mr. Clifford that the contact maintained by First American and its shareholders were through Mr. Aga Hassan Abedi, who acted as a liaison between both parties. And this was the first time that an attempt was made to contact the shareholders directly. Now that seems to contradict the notion that you had been in touch with them previously. It seems to contradict the notion that the shareholders knew that Mr. Abedi was the contact because you were informing him of that fact at that time. And I'm just, again, this just leapt sort of why does this appear this way, that there is a first meeting for the first time there's a contact in 1990 when nevertheless these people were supposedly participants on a regular basis?
Let me take a cut at it, then you follow. I think the wording that Mr. Assad has used is incorrect. When he says, this was the first time that attempt was made to contact the shareholders directly. I think what he means to say is, this is the first time attempt was made to contact the shareholders in person. Which is very different. We had contacts with the investors starting in 1982, but this was the first time.
Had there been any other, so I take it there'd been no meetings of the shareholders in person previously?
We'd had meetings with some of them in person, but I do not recall our ever having a call for all the shareholders either to come or send a representative. Do you?
I think there are a couple of comments, Mr. Chairman. First, with reference to the memorandum, which again I saw for the first time last night, I agree with Mr. Clifford's interpretation, although obviously we didn't write it. Incidentally, I think it is addressed to the chairman of the private department and not to Sheikh Zayed himself. But in this case,
I stand corrected. You're absolutely correct.
Mr. Azad, who worked for that private department, was new to the matter. He didn't have a lot of the background that others had, because this was really the first time he had become involved with the First American investment. Going back to my testimony that you made reference to, I say, I don't know the number of times I've talked to any particular investor. I believe over the years I would have talked to Sheikh Kamal Adam more frequently than any other investor, but it's just a guess. And what happened that gave rise to this meeting and the report on this meeting that you are reviewing in the document is that BCCI had served as the communications link. It is interesting that we did not have direct contact with Sheikh Zayed through the years. We had our contact through Mr. Abadi, and Sheikh Zayed is considered, to our understanding, by the Federal Reserve as a legitimate shareholder. So this concept of communications link and investment advisor worked in his case.
Let me say for the record that at least this senator is convinced, and I'm not sure of the rest of the committee, but I think that it's clear that Sheikh Zayed was indeed a legitimate investor and had significant.
And very likely the two other Abu Dhabi parties, one of them Prince Khalifa, and the Abu Dhabi Investment Company.
And I think there is no question they had significant sums at stake, and that is evidenced in a number of different ways here.
Correct.
In that regard, I would just say, so that the point is clear on the record, from our standpoint, that is, I think, speaking for the management of First American, we had no way to distinguish between shareholders. We didn't know that there were two groups of shareholders, some nominees, some legitimate. And the use of Mr. Abadi as a communications link and as an investment advisor was an appropriate use and one that worked in the case of these shareholders who are believed by the Federal Reserve to be legitimate shareholders. What happened, however, was that in 1990, in the spring, BCCI was acquired by the Abu Dhabi interests. And the management group that had been in London moved to the Middle East. It left London and moved to Abu Dhabi. And in the summer of 1990, I had a meeting with Kamal Adam in London, and I said that we had been using Mr. Abadi as our communications link, but Mr. Abadi, of course, is, because of health, no longer involved, and Mr. Naqvi, who we were using on a limited basis thereafter, is not going to be around, and BCCI is not going to be a major operation, and we need a new means of communicating with this group. Kamal Adam suggested, A, that he would, as he had been the informal chairman of the group, so-called, for many years, accept that responsibility. And further, he thought that we should have meetings at regular intervals, and he suggested that a representative of Sheikh Zayed, given their financial interest in the property, they were the second principal investor, should be invited. And so an invitation was also extended to a Mr. Mezroui, who was the chairman of this department which managed the ruler's investments. We decided to have such a meeting, but we extended an invitation to all shareholders who wanted to attend. It was going to be, in effect, a new approach to trying to create an effective means of communicating with these people, since the link that we had utilized for some 8 years was being severed and was no longer effective. And therefore, these letters went out. This memorandum reflects the fact that Abu Dhabi wished to attend the meeting, and they sent Mr. Azad, who, as I say, had no real background in it at the time, although a knowledgeable individual, sophisticated man. He was sent to the meeting so that he could get the report and take it back to the Abu Dhabi shareholder group.
Let me turn to Senator Brown, then I'm going to come back and perhaps be able to wrap up my set. We'll see where he goes. Senator Brown.
Thank you, Mr. Chairman. I had just a few brief areas that I wanted to cover. The first dealt with compensation. In your statements originally, you had mentioned that the compensation was very modest, referring, I think, to the compensation from First American, where you served as chairman and president, respectively.
That's correct, Senator.
I thought it would be helpful for the record to go through and accumulate what we can in terms of compensation. As I understand it, Mr. Secretary, your compensation was limited to $50,000 a year as chairman.
Yes, and remained that way all through the 9 years.
And Mr. Altman, as I recall the testimony, you did not take a salary for acting as president.
Mr. Clifford, as chairman, received a retainer. I received no salary and no retainer. I did receive director's fees for serving on the boards.
Can you give us an idea of what those would have amounted to over that period?
I would think that they would be the fees that were paid to all directors of the company, except for inside directors.
I don't mean to put you on the spot. If that's something you want to supply later.
I have a recollection that the directors were paid $12,000 a year basis, and then they received a fee for attending meetings, which may have been $500 or so. So it was in the area of $12,000 to $14,000 a year that was paid to the directors.
Which is a standard arrangement for boards of directors.
Yes, sir.
In addition, we've already talked about the stock transaction, and as I review the records, the combined before-tax gain of both of you was $9.85 million.
That's correct.
And after tax, that was reduced to somewhere near $4 million.
Yes, I think mine was $2.7 million, and Mr. Altman's was $1.3 million, so the total was $4 million after taxes.
And in addition, both of you would still have stock ownership of was it roughly 40% that you retained?
Yes, and that was paid up. In the transaction that took place there, the stock that we had remaining was paid up.
In that regard, Senator, in 1989 there was another rights offering, and Mr. Clifford and I each subscribed for some more stock. This is after we had held a balance from selling the first block that we had purchased. We bought some more stock in 1989, and incidentally, that stock was not financed by BCCI. There were no loans, in fact, from a bank. And then in 1990, there were convertible debentures that were issued by the company in an effort to raise capital, and Mr. Clifford and I each purchased our pro rata portion of those convertible debentures.
Well, of the stock that you had purchased originally, which appears to me to be 2,200 shares for Secretary Clifford and 1,100 shares for Mr. Altman. Do we have a way of coming to a figure as to what that would amount to? It looks to me, if you value it, that at $6,800, which was a figure we'd used earlier, that comes close to $22.9 million. I guess the question is...
We'd be glad to sell it at that price.
Yeah, what's an appropriate price at this point? Do you have a feel for that?
Yes. I wish to make 2 points. One, the fact that we had one transaction at the $6,800 figure did not set a price at that time. In very narrowly restricted sailings of unlisted stocks, one sale does not set a price. We mentioned that earlier. Different prices are agreed at depending on how much the buyer wishes to pay for the stock. So that one transaction came and went. Now, with the stock that we own today, unfortunately, there is no way to value it for the conditions that exist today result in that. The stock is widely distributed, but we don't know where it is. Some of it may be held by the liquidators, some of it may be held by Abu Dhabi. We do not know. I don't believe anybody knows where the stock is distributed today. Also, the value of the stock obviously is much lower because of what has happened to economic conditions in this country. Just as an illustration, I was checking some figures in this relationship. Riggs in 1988, that's the year when we made our sale, Riggs stock was selling then at 48. Was selling then at 26, and as of now, the 1st of August, it was selling for 8. So there's been that amount of decline. The other one that I noted, which is one of our main competitors, that's the Maryland National Bank. That stock was selling for 48 in 1988, and on August 1st of this year, it was selling for 4 1/8. That's the precipitous decline that has taken place in bank stocks in this area because mainly of the collapse in real estate values.
Do you have a feel for what book value would be
Today, it's
in the neighborhood?
well, it's come down. When we first bought our stock, it was 2,200, and then in the next 4 or 5 years, it worked up very close to 3,000. Then came the precipitous decline in bank stocks and the loss in real estate values, which caused us to take our first loss in our 9 years in 1990. All the banks then suffered substantial declines in book values. I don't know even now if it would be 2,000. It probably is less.
It's approximately $2,000 a share. Although, Senator, you would understand that most bank stock today, unlike the case in 1988, sells at a substantial discount from book value. As Mr. Clifford indicates by the numbers, say, of Maryland National, one of the biggest banks in the area, selling at $4 a share, or Riggs at $8, something like that.
Well, as I went through this, if I've read the record correctly, and I guess I've presented so that you perhaps will straighten it out. In this process, the law firm, your law firm, provided legal services and received fees, presumably, from a number of parties in this area, BCCI, Burt Lance, CCAH, CCAI, FAC, FAB, the parties you represented in the original takeover of the FGB, and there is some indication in the record that you may want to comment on that you had the ability, at least, to designate other law firms to handle BCCI business. I don't know if that resulted in referral fees or not. Would all of those be correct? Were there fees that the law firm received in all of those entities?
Let me give the part of it that I know about.
I've given you a long list, so please don't.
All right. I think I can get to it quickly. The representation started at the time the litigation began. That would be back in 1978. So that the relationship with the investors began then. The litigation lasted maybe 3.5 years. When the litigation was over, the investors indicated that they wished our law firm to continue to represent the properties which the investors now owned. Yeah, as you are already familiar, there are 3 shell companies at the top for tax purposes: CCAH, CCAI, and First American Corp. Then comes First American Bankshares, and the investors asked that we represent all of those whenever they needed counsel. Most of our services were rendered to the operating holding company, First American Bankshares. And that started out at a lower figure when the bank was not so large. And as the bank expanded, then the cost of legal services expanded. Fact is, our law firm served as the legal division of First American Bankshares. They didn't have to go out and hire lawyers. We supplied them with the lawyers. I would give you a little idea of the overall picture. I would say that through the 9 years, if I tried to average it, I would say that about each year, the total cost of lawyers to First American Bank Group ran between $10 and $12 million a year. And of that figure, the amount received by our firm would average about 1/10 of that, or maybe $1 million a year.
That would include the First American Bank Group. Would it also include the fees from BCCI?
No, that would be a separate matter. And those fees were nothing like the fees that we charged First American Bank, because there wasn't nearly that much work to do. We had no regular work for BCCI. It was at the end of the year we'd look back over it and figure the items on which they had called on us. They were not very many. It would just be an occasional matter that came up that they would call on us, because they used White and Case, and sometimes Sullivan and Cromwell in New York, Morrison and Foerster in San Francisco, Holland and Knight in Florida. I think, as a matter of fact, they used them a good deal more than they used us. And also, if I might just insert a parenthetical comment, oftentimes we've been approached with the thought, well, you must have known what BCCI was doing because you represented them. That does not follow. They used us only on selected matters. We were not their general counsel. And just to put it succinctly, they told us only what they chose to tell us. That's the situation.
Well, I appreciate in looking at these figures that the amount of billing is obviously different than what the take-home pay might be from these kind of services, but I thought it was important to get a feel for the volume that was involved. One of the
correct.
things I had a question about were referral fees. Did the firm also receive compensation for referral to other law firms?
I know of no such situation. I do not know of any case in all the years we've had our firm, 41 years, that we have ever charged a referral fee for a matter which we referred to another firm.
And incidentally, so that the record is clear, Senator, we did not have the authority to designate a law firm for BCCI, but we would recommend law firms to BCCI. They had to make the decision to accept it, which they would do in cases we were called upon, but it was not our authority to pick their law firms.
You had also mentioned in your testimony that there were no financial improprieties in the way First American was managed under your leadership. We had testimony earlier that one of the traits or characteristics of BCCI was to seek to gain favor or a working relationship with political leaders, and that in that regard they made donations to charities, they made payments to the individuals involved, and a variety of other things. I thought that was an area that would be helpful to try and put on the record. First of all, let me ask, was it First American's practice to loan money to political campaigns?
No, it was not.
As a matter of fact, Senator, my recollection is that at our request, they adopted an express prohibition in the lending policies from doing that. We did not think that was a business that First American should be in.
I think Senator Kerry and I first both appreciate why that might be considered somewhat risky business, but
Speak for yourself.
I'll speak for myself. Did First American loan money to political campaigns?
Not to a campaign that I've ever been conscious of.
The only instance that I'm aware of, we at one time became aware that there was a loan which we had no prior knowledge of that had been made to, I think it was then Senator Hart, Gary Hart, and that was one instance. But we had adopted a policy, and I'm not clear about that loan. I think that loan was paid off, and we had adopted a policy that we did not want to be in the business of making loans to finance campaigns.
Was that after the Hart loan, or do you recall?
I don't recall, but I know it was something that was a holding company directive. We did not believe it was an appropriate business for First American. Even though we were not sitting on loan committees, we asked that our banks not be involved in that kind of lending. And I think that's reflected in the loan policies, although I don't have them.
So as far as you know, that was the only one that you recall?
It's the only one that I ever heard of, and I think we inherited that.
What about to political leaders themselves? Can you give us an idea if that was a practice of the bank to?
First American was one of the dominant banks in Washington, D.C. There are really three major banking institutions in this market by market share: First American, Sovereign, and Maryland National. And I am confident that all three banks, as well as others such as Riggs, have loans to people who are involved in government and politics. But those are not political loans. If someone needs a car loan or someone needs a mortgage loan, they certainly aren't disqualified because they're in political or governmental service. So I'm sure we do.
To your knowledge, were any of the loans to political leaders granted at involving special treatment, that is lower interest rate than normal, less security?
I've never heard of such a case.
I know that House Bank used to assist members in finding loans to finance. I hadn't realized that the service wasn't needed at the time. Was First American a referral bank for the House Sergeant at Arms office? Are you aware of that?
I'm unaware
Because I
of
know
it.
they did refer.
I was unaware of the House
several
Bank until the recent publicity, and I am unaware of whether they ever referred any customer to First American.
Did the bank ever engage, make political donations with the bank's money?
Not that I ever heard.
No, sir, not to my knowledge. Individual officers can do as they will, but not as a corporate matter.
Thank you, Senator Brown.
You.
I just wanted to come back to one thing you said, Mr. Altman. You mentioned that you did learn that the bank, the First American had account for CIA or accounts, therefore. How did you learn, how did you learn that? I was curious.
It came up in a conversation I had with the chief financial officer, where he indicated to me there are certain authorities that are granted to banks that have those kinds of accounts, and I became aware that we had some of those accounts at First American. I don't know.
Do you remember when it was, approximately?
It was this year.
This year. And what kind of authorities was he referring to?
It was who is entitled to handle those accounts. There's certain requirements that the banks have to follow for special accounts, but I didn't get into the specifics. It's only that when you ask the question, I am aware that there were certain relationships.
Now, let me ask you something that's been a puzzle to a lot of us as ex-private sector attorneys and now as public officials. The $45 million cost of litigation on the money laundering. Your firm acted as the paymaster, in a sense, for that, and I believe one or both of you was sort of the head of the team, and you had Mr. Banoon and Mr. Wexler and others below you, and then a tier of lawyers in Florida. But when one looks at the payout on that, starting in 1988, 11/30/88 with $1 million paid out, 11/30/88 a separate payout of $650,910. 1 month later, another $1 million paid out. The same day, another $1 million and $32,000. So in the first month and a half, you got close to $4 million out. And then you've got a series over 1989 of payments of $900,000, $595,000, $1 million, $1,001,000, $1,843,000, $1,001,000, $750,000, $583,000, $1,035,000, $500,000, $334,000, $1,338,000, $1,250,000. This is all 89, and it still goes on. 1 million, 1 million 2, 2 million 1, 2 million 3, that's 89. Then you go into 90, and you got 335, 643, 250, 693, 1 million, 1 million, 909, 1 million 3, 1 million, and so it goes through 90. Those are mind-boggling payouts, I think, to anybody just sort of sitting here. Can you shed some light on what happened in the course of this litigation that was so expensive, and what people did, and who received that money?
Let me try. First, Senator, you have used a figure that we heard also before House Banking, and that is $45 million. I'm not sure where that number comes from.
Well, it's the total of all the numbers I just read out to you.
Well, I don't happen
BCCI
to have
payments for legal defense fund managed by Clifford Morenke, statement date, and there are a series of statements with specific amounts. BCCI's Board of Directors authorized payments for the legal fund to be handled by First American.
I don't have a copy of that document.
This is a document from the House Banking Committee. Have you not seen that?
No, sir, I have not.
Can we, I thought they'd seen, this was the House. I think this came up in the House, which is why.
Well, they used the figure in the House, and we didn't know how it was computed.
Well, I got the payouts here.
We never got a copy of that, Senator.
It's fascinating. There was one payout for $6. Well, I'll get a copy to you right away. It may be inaccurate. This is what I'm trying to find out.
Let me give you a couple of observations, if I might. The amount of money that I'm aware of, now I haven't studied these figures, but the amount of money that I understood was paid in connection with this general effort was half that, approximately $20 million. That money was not expended simply on the defense of the Tampa proceedings. The money went to law firms. The money, a substantial portion of the money went to Price Waterhouse, and the money went to various other kinds of costs. And let me give you a feel for why. After the Tampa case was announced, BCCI then had substantial legal problems in a number of parts of the world. There were investigations that were commenced in London. There were investigations that were commenced in Luxembourg, investigations in France. In addition, there was a general belief, as an evaluation was made of BCCI and people really started to take a hard look at BCCI, which we had the opportunity to do for the first time. It was clear that BCCI's operating controls and procedures were seriously deficient. And a substantial amount of time and money was spent analyzing their controls and writing new kinds of controls that would prevent money laundering abuses in the future, Bank Secrecy Act violations in the future, a large number of controls that one would have thought that a bank or these were then agencies, but agencies that have been operating for this period of time would have had in place.
You know what I think we can do to try to save some time here? Accepting that, what would be helpful to the committee is if you could provide us with some sort of a correlation of these payouts to entities, and I think that would result. I don't think we need to spend a lot of time on it.
I think there may be a confusion of accounts, but I'm not
There may well be, and I'm not
sure of that.
I want to make it clear, I don't know with specificity what this is. This is a document that came from the House. It has the statement dates. I can't even tell you with a certainty that each and every one of those figures belongs in the legal fund. So, but this is based on testimony, may I say, of a number of the bank personnel who have said that was the amount that they paid and that it cost them. And there is some information from the bank itself that has argued this amount of money. So that's what
another
it's based
factor involved. When the indictment came down, that was in the fall of '88, they not only indicted BCCI, but they indicted 9 employees of BCCI. And BCCI made the decision, which corporations sometimes do, to also extend and pay for lawyers for each of the employees. So it isn't just bills to BCCI.
No, I understand that.
Every one of those individuals had to have a different law firm. And every one of those lawyers felt that it was very important that he give a lot of time, and I'm sure there was a lot of duplication. But there was more than one.
If I had a bank
involved.
paying the bills, I'd give it a lot of time too. So it's, you know, I'm just
But
saying,
one,
I think $1 million per defendant in a case like that, assuming, I mean, that only gets you halfway to the 21 on the individual defendants, and it's an extraordinary sum of money per defendant.
It's also been suggested that in occasional pieces that we profited greatly from this matter. The fact is, not one penny of that fund came to us.
I appreciate that comment. The committee didn't ask that question, and we haven't alleged that. So
I would just note for the record, Senator, that that trial went on for about 6.5 months, and as you know, legal costs are quite high.
Understand that. All we're looking for is a breakdown so we can understand it.
Right.
We would be glad to.
Now, coming back again, and we are going to get through here, and before too long, this is not a deposition, it's a hearing, and it reminds me why I'm glad I'm not doing depositions and I'm doing hearings. But let me ask you a few other areas of concern that have been written about publicly as well as testified to here. The annual conferences and your participation in them has been an issue of concern, which has been expressed on a number of occasions. People have said, well, Mr. Altman was in Vienna at the conference, or Mr. Altman was in London at the conference. And I choose Vienna particularly because in 1984, Mr. Roy Carlson of the National Bank of Georgia was there. People were there from Attic Oil, from the BCCI Foundation, from the National Bank of Georgia, from a whole bunch of individual affiliates. The question is, you testified earlier that you sort of had some feelings about the similarities of National Bank of Georgia with BCCI. You saw that it had the same structure, the same logo, the same this and that. Now, we're told by individuals that Mr. Carlson would talk openly at these events about his relationship, sort of being part of the family. And my question to you is whether or not you ever learned or even had greater suspicions as a consequence of these international conferences that there was some deeper relationship between the National Bank of Georgia and BCCI than met the eye.
Senator, the conference to which you make reference is 1984, the Vienna conference. I'd be glad to explain for the record, if you'd like, why I attended, but if that is not the focus of your inquiry.
That's not the focus. The
Okay.
focus is really whether or not you got a sense in the course of it of Mr. Carlson's and NBG's link and the nature of its relationship to BCCI.
I don't recall hearing Mr. Carlson speak at any conference. I never spoke at the conference. And in 1984, I was not really aware of the manner in which NBG operated. I became aware of it when we took an interest in acquiring the property, and then we got very deep into the manner in which they operated when all this became quite apparent to us. But back in 1984, I gave them no real attention.
In 1986, Mr. Afridi and you and Mr. Ellie attended a Luxembourg BCCI conference.
Right.
Was that in the same nature of, you've testified, I know, previously, and I said I don't want to go back through everything that you've already got on record, but was that simply part of the relationship that you've testified to earlier in terms of communication, or was there another reason you were there?
Well, I was there for a couple of reasons, I suppose. I was invited to attend. BCCI was then a client of ours, and BCCI also had a close relationship with the owners of First American, and as a matter of good relations, both as a client, and they did parenthetically invite lawyers who represented them over the years to attend some of their conferences. So this was not unique to me, but both because they were a client and because they had a relationship with the shareholders, I attended the conference. I think it's important to note that these were not meetings where BCCI's secret business or strategies or even much business at all was discussed. They were, perhaps you've had testimony as to the nature of the conferences, but they were largely philosophical in nature, if I might call it that. Mr. Afridi attended the conference. He was working on international for our New York bank. He and Mr. Ellie both had contacts with BCCI because they had come from that organization, and when he returned from the conference, he wrote a memo to Mr. Duncan, the CEO, detailing the amount of business that he was able to obtain as a result of going there. One of the things we constantly tried to do was to compete for BCCI's business, most of which went to Security Pacific and Bank of America and these other banks, and we were very eager to try to handle that business because it was profitable to us.
Can I ask you, I'm sorry, Mr. Secretary.
One year, we sent Robert Stevens, who was president and CEO of First American Bankshares, and he took a box of his cards with him, and it was his job in 2.5 days or so to try to find the manager of every one of the 70 banks that BCCI had. Give him his card and say, if you ever need a banker in the United States, you now know me, and please get in touch with me. Said he gave away every card he had.
Did you have this kind of relationship with any other bank in the world?
Well, we had a lot of correspondent banking relationships.
But did you go to the conferences, and
No.
were you in a consecutive way as much a sort of member or partner or whatever, I know you don't want to use those words, as much of a presence?
Well, there was no other bank where we attended their conference. This was
Conferences, right.
something unique to the way they operated, where they invited people in.
Why did you think the National Bank of Georgia was there all the time? Every time you went,
My
they were
understanding was that Dr. Ferrone owned the National Bank of Georgia. He was a major shareholder of BCCI, and he wanted his people exposed to BCCI concepts. That was kind of the rationale that was given.
It never struck you that the fact that it was always NBG and First American and BCCI for, what, 1982 to 1989, 7 years, that people weren't gaining something out of that, a sense of affiliation, a sense of a unity, and the kind that's been described in the terminology put forward?
Well, first of all, Senator, one correction, if I might. It's my understanding that the last such conference was held in 1986, nearly 6 years ago. These didn't continue throughout the years.
You bought the bank. You bought National Bank of Georgia, correct? In 86, 87.
Well, we bought National Bank. No, I'm saying that BCCI conferences where people came and attended were not. You indicated they went on for 7 years, and
No, the relationship. I'm not saying the meetings went on, but the same kind of. If it wasn't a specialized conference, it was a specialized referral. If it wasn't a specialized referral, it was a, for instance, why did you put a $75 million certificate of deposit in ICIC?
A couple of points there that we raised several
But you see, these
subjects.
kinds of things keep cropping up.
First, First American and BCCI did have a connection that First American and Citibank did not have. And that is, we had our shareholders who also had a substantial financial stake in BCCI. So you had this, at the ownership level, this overlap. So there was a relationship there that is different than a relationship that existed with other U.S. institutions. This, parenthetically, was also known to the regulators at the time.
That's an important question here. What you're saying to us is that it is your interpretation that the Fed signed off on that. I mean, that's what I'm hearing.
It was expressly provided. They asked us, and we gave them that information during the regulatory proceedings.
I realize that, but taking the Muckenfuss letter, which is the controller of the currency, went to the Fed made its decision.
Right.
And you're really saying that the Fed approved of precisely what followed. Is that correct?
No, sir, I wouldn't say it quite that way. I'm not sure when the acquisition was made, anybody could ever say precisely what's going to happen, or even generally what's going to happen for the next 10 years. But the Federal Reserve had a specific overriding concern. And I think it's important to get this on the record, because whatever happened at BCCI and whatever happened to the stock of this company, and these are matters that we don't know, but the Federal Reserve had some specific concerns. They want to know who's going to run First American. Is BCCI running it? Is this American board running it? And we said, this American board is going to run it. We are making the decisions. We are not controlled by BCCI. And the Federal Reserve has now stated several times recently after all their audits that that is true.
That is true as to First American in 1990.
Well, they came in 1991.
In 1991, but they looked back at the operation which had fundamentally changed in many ways.
Well,
I mean, I don't want to really belabor this because I don't think it's going to be a sort of an arguable kind of thing.
Well, the other point that I want to make is you were indicating that BCCI was managing our business or directing business or somehow assisting us, and that isn't the way this operation went. Now, I don't know what was in BCCI's mind, and I can't attest to what some of those people said or what they may have done unbeknownst to me. But you can talk to every director at First American, you can talk to every CEO at First American, and they will tell you BCCI did not run or control their business. I heard Mr. Sakia's testimony, which was one of the few portions of it that I heard was considered with some amusement, when he indicated that BCCI was this very professional, skilled, efficient organization that had to deal with First American, which was kind of a bureaucratic, bumbling organization, the way he described it. I think our record would speak for itself. I don't have to. It's another one of the areas of Mr. Sakia's testimony that I think the committee could look at more closely. We ran First American. We made the decisions. We ran it honestly. We didn't need assistance from anyone else. We competed for BCCI's business, most of which went elsewhere, despite our competitive efforts, although over time we were able to get it. The amount of business that BCCI may have referred to us, while I haven't analyzed it, I would suggest to you is minimal. They weren't even in the businesses that we were in. Our primary business was retail banking. It was banking to small businesses, real estate, more real estate than perhaps we wish we had now. BCCI wasn't in this business, and they sure didn't know these businesses as well as our professional bankers.
With respect to that sort of business relationship, let me just ask a couple of other questions on the acquisition of NBG. You asked Mr. Scafoni, is that the correct pronunciation? Scafoni?
Yes, sir.
Scafoni, to analyze the acquisition or potential acquisition of NBG. And he came back with that fair purchase price of 2.5 book value, which worked out to 160 million.
211 million.
211 million with cash of 160 and 51 million of CCAH stock, correct?
I'm not sure where you're getting that number. There is under tab 20 of my book, Senator, there is Mr. Scafoni's memo dated May 7,
correct, that's what I'm looking at.
1986, and he says, it is my opinion that a fair purchase price for NBG would approximate 2.25 times book.
Correct.
This would yield a purchase price of $211 million.
Right. On the next page, he suggests 160 in cash, 51 million through stock.
Oh, I see where you are. Okay.
Yes. Just splitting it up, it's 211 million. Yeah. Now, I gather the ultimate sale price was 250 something?
No.
The ultimate sale price was $227, but that is, there's a wash item in there. The actual price that was agreed upon was $210 million. There was a $10 million
suggested to him that you hoped you could negotiate, quote, your paragraph 7. It is hoped that negotiations would produce a deal for $160 million to $175 million in cash with no stock. Mr. Scafone provides information concerning various other bank sales, but it's clear we are nearing the point at which this purchase is too expensive. Now, why did that suddenly change? What happened to make it $220 million when $175 million with no stock was deemed to be too expensive by you? And you see, the reason this sort of gets flagged again is people keep getting out of these transactions with their full obligations paid. In other words, Mr. Ferrone needed X amount of dollars to get out of there, to pay his note, and to not have any exposure of BCCI in the event that people came after him for his failing businesses. So to get him out and cover it, in fact, on the paperwork, it works out that if he got the 225, BCCI is no longer exposed. So the question is, why did you, if you thought the price was too expensive, let it go up so that he got out free and clear and BCCI is happy if you're purchasing this bank on your own?
Let me state unequivocally, we were purchasing the bank. This was a decision that we made. And let me explain also that I am unfamiliar with the financial situation of Dr. Ferrone, so I can't comment on whatever lending arrangements he might have had. I had some different understanding at the time about his situation, but that may not be relevant or accurate. What happened, and it often happens in corporate acquisitions, I think American history is replete with these kinds of transactions. We got into a competitive bidding situation. NCNB, North Carolina National Bank, a very aggressive bank, also had identified the National Bank of Georgia. They had a strategic concept, as we have subsequently discovered, virtually identical to our own. They thought it made sense for the same reasons we thought it made sense, and they started bidding against us. They flew to France, that team of them flew to France, they met with Dr. Ferrone, and they upped the bid, and the bids kept going up. They made a bid of $210 million, roughly. I think it was $4 million worth of their stock, at then trading at 52 and a fraction.
This is NCNB?
NCNB. So they made a bid of $208 or $210 million, and if we wanted the bank, we had to match the bid. That's what happened.
Now they...
And NCNB would confirm for you that was their bid.
Now, just a point of curiosity, I'm reading the next sentence here, and we have never seen a written bid from NCNB. Why would you expect to see a written bid from NCNB? If NCNB is competing against you for an independently owned bank and you're writing Mr. Nakvi, the only thing you could expect is that Nakvi was going to let you see their bid so you could know how to counter. Would that happen in a transaction like this?
I think the point I was making is we are hearing that NCNB is getting into this and getting very aggressive, but we're upping our bid and we're talking millions of dollars without having real confirmation that this is what NCNB...
But how would you get that confirmation? Would you ever see a written bid from NCNB?
No, I would not see it. I was just commenting...
Why would you write that? That you would say we haven't seen it unless you expected Mr. Nakvi to show it to you?
I don't know if, in fact, NCNB made a written bid. The point that I was making, I am observing here that we haven't seen anything in writing. All we know is that Dr. Ferrone keeps telling us that the bid is going up. And whether he's telling us that accurately or not, we don't know. We'd like to see some confirmation before we start competing against ourselves.
I might interpose this thought there. We later learned from NCNB that they did make that bid, and I think it came to $208 million.
Oh, I know.
But their bid was in stock.
I know that
our
NCNB
bid was in cash.
I know NCNB was interested in it, but there's no question about the legitimacy of their interest. the question is, because of other testimony we've had which suggested that Mr. Abadi wanted your bank to buy it and that the decision had been made in Florida to do so, that NCNB was an harassment here. They were sort of in the way. And the way in which the shareholders were able to now not make this too expensive was because BCCI loaned them the money in order to beat the NCNC bid so that they could buy. And that's ultimately what happened. They loaned them the money, didn't they? Wasn't there?
I don't know. I don't know if BCCI loaned them the money or not.
But that's what you testified to in the House. You said that you came up with the extra money, and the way the extra money came up was through BCCI.
No,
Excuse me, not through BCCI.
No, sir, I don't think I said.
I'm sorry, I apologize. I'm incorrect on that. Where did the extra money come from that permitted
We did
that?
we did a rights offering in '86, and we did a second rights offering in '87.
But this was to the existing shareholders of CCAH.
Yes, sir.
Correct.
And the first rights offering was for $150 million, and the one in the summer of '87 was for $115 million.
But wasn't some of that offering taken up by loans to those shareholders through BCCI?
It may have been. We don't have that information.
I think it was. I think that's what I'm referring to. So in effect, BCCI enabled you to make that sale or to make the purchase by virtue of your shareholders, who are all part of this family, being able to buy over the NCNB bid.
Well, even if it is correct, and I accept what the chairman says, even if it's correct that the shareholders borrowed the money from BCCI, I would have to say I see nothing impermissible about doing that. If our shareholders want to buy NBG, and if they are meeting the market price as set by a competitive bid situation, however they raise their money, as long as these are legitimate loans and not shams, it's not a prohibited transaction. Now, there were representations made to regulators about the source of that funding, and it would have to be consistent with those representations. I do, Senator, want to go to one fundamental point, however, and that is the testimony that this committee received that Mr. Abadi made the decision for us to buy the National Bank of Georgia. Perhaps rather than hear from Mr. Clifford and me again on the subject, it would be helpful if I were to read to you from an affidavit from one of the directors of the company at the time. His name is Lee Jenkins. He was the president of a New York Stock Exchange listed company. He was, incidentally, a man who was very skilled in mergers and acquisitions, very financially astute and sophisticated, and he says the following in his affidavit. With respect to the acquisition of the National Bank of Georgia, the board was presented with the relevant financial data and was apprised of the status of the ongoing negotiations throughout the acquisition process. The agreement to acquire NBG was approved by the board of FAB's parent. One of the principal reasons for FAB's decision to acquire NBG was that NBG's central location in the Southeast satisfied one of the bank's long-term strategic objectives of expanding in the Southeast. I believe the other directors concluded that the purchase of NBG represented a unique opportunity and was in the best interests of First American Bankshares. BCCI had no influence on my conclusion, nor to my knowledge on any other director's conclusion, that the purchase of NBG was in the best interest of the First American organization. To my knowledge, BCCI did not, in any respect, cause First American to acquire NBG.
Well, let me say, again, it is not my role to argue this, and I feel uncomfortable coming back to you. You know, there is a way to explain that, as there is everything in this, and it is that once a decision had been made to try to affect it, you obviously had to get a board of directors and other people to approve it and go through it. There wasn't any question about that, and I'm sure BCCI didn't touch any of them in the effort. It was a good deal, and I'm sure for First American it made a lot of sense. But in terms of the testimony originally made by Sakia and Rahman and some of the documents, it just raises the question as to it. You've answered that. I'm not trying to suggest to you that, but it's hard. It's hard to pick one's way through that because there is not a total relevancy to whatever happened to the Board of Director decision.
Excuse me, sir.
If I might add one factor. There has been criticism of First American for expending this amount of money to acquire the National Bank of Georgia. People who make that criticism just do not understand what happened. We had a rights offering in '86 that produced $150 million. We had a rights offering in '87 that produced $115 million. So there came to us from the investors, then I have to add, and our BCCI, because we don't know which is which during that period. But there came from the investors in BCCI a total of $265 million from those two rights offerings. The money that we paid to buy the National Bank of Georgia came out of that $265 million. So we end up with BCCI gone broke, all this thing in a terrible mess. We end up owning the National Bank of Georgia, and we didn't put any of our own money in it.
Let me...
Excuse me, sir.
No,
One
no,
other
go ahead.
comment I would make for the record, you made reference to Mr. Sakia. I think it's noteworthy that Mr. Sakia was very careful. He did not say he was in any meeting where he heard that decision
Let me just say for the
made.
record that, and it's something I meant to observe that day, that the committee is well aware, at least the chairman is well aware, that Mr. Sakia was careful to choose where he was involved and where he was not, and we understand that Mr. Sakia himself is under investigation. We know that with respect to the Bilbezi coffee smuggling case, there are serious issues. We understood that before he came here, and we sort out what he says in that context. So I just want to make that part of the record here. And I am aware that he faces some legal issues with respect to that, and the committee puts it in that context. So,
Yes, sir.
Let me, before I come to the tail end here and ask if you, and I'm going to submit some of these questions in writing because I don't want to sit here and nitpick at some of the stuff that has to be asked because it's there and it's been raised, and I think the committee is not going to be capable of doing its job if we don't have the answers and there isn't a record there to deal with it. One other issue that is of concern to the committee, and I know, gentlemen, that you were aware that we were somewhat concerned about it because we articulated it at the time, and that was the response post-subpoena, the question of the production of documents and the whole issue of Mr. Amjad Awan. There is a memo that came to our attention recently through this process of discovery, which was originally covered by attorney-client work product privilege. It came from the confidential file of BCCI. It's one of the documents that you have. I think it is document number 39. No, excuse me, 42. And it is a document which involves our committee and our work and reference to the subpoena served on you and Mr. Benoon. Now, I notice an error immediately right there. There was no subpoena served on you or on Mr. Benoon. And then subsequently, it raises an issue about suggesting in response to the subpoenas, the source stated that Altman and Benoon are opposing the subpoenas, doing everything within their power to call in political markers. It may be that Altman and Benoon will succeed in quashing the subpoenas and so far. Would you share with the committee, please, what, if anything, you did commensurate with what is asserted in this memo with respect to the committee subpoena and request for documents?
First time I saw this memorandum was last night, Mr. Chairman. I had seen a reference to it in some news article recently. I have no idea what the author is talking about when he talks about calling in political markers. As you've observed, I was not under subpoena, and to the best of my recollection, I didn't talk to anybody on the Hill about this particular matter. The committee had scheduled a hearing in the summer of 1990, in July. Mr. Banoon was on vacation out of the country. I believe he got in touch with your staff. There were some issues that had to be resolved relating to attorney-client privilege and the like, and Mr. Banoon worked those out with your staff, but I was not calling in political markers or doing anything to try to quash a subpoena. I don't even believe I responded in writing to the committee to ask for any delay.
Do you know who, if anyone, contacted Senator Hatch with a speech defending BCCI?
Yes.
Who did that?
Well, there were several people. This would have been in the winter of 1990.
This was right after the plea bargain, I believe, or right around
that time.
Yeah.
Senator Hatch was a member of the Judiciary Committee at that time and had taken an interest in this particular case. He had wanted a briefing on the case originally, and I knew Senator Hatch, and I went to see him along with the attorneys of record. I think it was then Mr. Wexler and Mr. Barcella. Mr. Banoon may have been there. I'm not clear about it. Senator Hatch indicated that he felt the criticism that was being made of that plea was unjustified, and he was intending to make a floor speech about it and ask for information. I know that he also contacted the Justice Department. I think he got briefings from them, although I'm not sure of that, before he made that speech.
Recently, an article in the National Journal quoted Mr. Banoon as saying that the subcommittee was, quote, out-lawyered after previously advising us that he wanted to cooperate with us, and that was his goal. That's okay by me, but my staff is outraged. But do you know what he meant by out-lawyered with respect to the process of production of documents and cooperation?
I do not, sir. I know that Mr. Banoon felt that the original subpoena was not well drawn, a matter that he discussed with Mr. McCall of your staff, but I don't know what he had in mind.
You don't have any sense beyond that?
No.
Was there any intentional withholding of information about BCCI for any purpose?
No, sir, and no intention to mislead this committee.
What happened with respect to the Noriega checks? We had requested a number of checks indicating Noriega. There was a production of some 4 checks after a considerable period of time. We now have some 35 checks, I think it is, all drawn from First American, which were, these are items, item 41. And these are all checks drawn on or passed through, I believe. But I guess the question is, these were in the country, and we received notice that there were none in the country, and then later on, only through the liquidators? Where did this come? Yeah, ultimately, through the liquidators, they provided this. And so that gives rise to this question of why that wasn't originally provided. Can you shed any light on that?
I think I can, Senator. When a subpoena is issued to a corporate client, the lawyer necessarily relies on that client to advise whether there are responsive documents. And at the time, we were advised that there were no responsive documents and within the United States, and subsequently, when it was determined that there were documents that relate to Mr. Noriega within the United States, an effort was made to get BCCI to find these records and produce them. It is my recollection that BCCI's records were so chaotic that we had BCCI as a customer of First American make a request of First American for every check ever written, so that someone could go through the checks and find out if there are any checks that are responsive. Now, I have not seen the documents here. This appears to be from the check books that have indications of Noriega that are not on the checks themselves. I wasn't involved in this particular search, but I can only say to you that a lawyer has to depend on the client to at least give him the universe of files so that a review can be made for responsive documents.
Who gave that advice? You said you were advised. Do you know who?
Well, originally what happened was that the subpoena was issued in the summer of 1988, and a meeting was held in Miami with a number of BCCI officials, including Mr. Awan. And Mr. Awan, that all of the BCCI officials told us, was the only person who knew information about the Noriega account. They all said they didn't have any information about it. That they knew of the relationship, but they said he is the one who has the.
Did you meet with and talk to Mr. Awan?
I did, and he said that very directly to me.
With respect to Mr. Awan, as you know, there have been a number of people who have alleged that he was told to leave the country, and I know you've commented publicly on that once before, but I want this record to address the issue.
Good.
And I guess Mr. Sakia again testified that he had heard from 2 or 3 different people the same thing. Was there any such instruction to Mr. Awan?
I'm glad you raised the subject, Senator, because I want it on this record. I want it every place the subject has been raised. I think it is unfortunate that it has been raised, and the record here should be very clear. The original subpoena that was issued by this committee was directed to a Mr. Khalid Awan. That subpoena was served on a Mr. Khalid Awan in Miami. In mid-August, August 16th and 17th, as I recall, 1988, we went down to Miami, I together with 2 other lawyers from the firm, to go over the specifications of the subpoena and to see if there are responsive documents. When we got down there, we realized that the subpoena was directed to the wrong person. In fact, what happened was, as I recall it, I looked him up in the phone book, and I called this individual who said, yes, he had been subpoenaed. He didn't know what it was all about. He had nothing to do with BCCI. It was clear there was a mistake. We immediately, I believe we did the very same day, called the committee, spoke to, I believe it was Kathleen Smith on the staff, and advised that the subpoena had been misdirected. I suggest that this conduct is wholly inconsistent with the notion that when we learn someone is trying to serve Mr. Awan with a subpoena, we tell Mr. Awan to get out of the country. Now, we interviewed Mr. Awan, and Mr. Awan, in point of fact, had very helpful things to say about the issues that the committee was investigating. Mr. Awan stated quite flatly that BCCI was not a bank that was engaged in drug money laundering. It's the kind of information we certainly want this committee to hear. The problem was Mr. Awan expressed quite clearly that he was afraid of Mr. Noriega. He was concerned about his personal safety. And he was fearful that if he testified, reprisals would be taken against him. The management of BCCI, in response to this, indicated that they were going to transfer Mr. Awan to Paris in order that he might have a lower profile and lessen the risk of reprisal or injury from Mr. Noriega. But this was not a matter that was kept secret. by coincidence, on the day that Mr. Awan has his taped undercover conversation, and that was the 9th of September, we had a meeting with the staff of this committee, and we advised the committee at that time that Mr. Awan may be transferred to Paris. So we were not keeping this a secret from the committee, and the effort here was not to prevent Mr. Awan from testifying. The concern was, as Mr. Awan states in that same undercover taped conversation, quote, "The reason being that if I say anything about Noriega and it's reported by the press, I'm dead. He's going to kill me." Now that's what Mr. Awan was saying to us at the time. And when we talked to the staff of this committee, we were told that this was not fanciful, that indeed there were true risks about making disclosures relating to Mr. Noriega. We advised the staff of this impending transfer, but we suggested to the staff that if they truly wanted to understand BCCI, and I might note that the staff had told us when we first got into this in August of 1988 about the allegations about BCCI, and we then go to BCCI and ask them about it, and we hear a dramatically different story, totally inconsistent with the allegations. And we said this committee should talk to the senior management of BCCI and hear from them directly. They were very convincing. And we suggested to the staff that they go to London and they meet with a Mr. Rizvi, who is in charge of all of these operations in this hemisphere, and Mr. Naqvi. And we said if they would make that trip, and if Mr. Awan is transferred to Paris, then Mr. Awan can come over and give his testimony. You're not going to be deprived of your testimony. But the point I'm trying to make is there was never an effort to prevent Mr. Awan from giving his testimony. There's two other items I would note. The first is that Mr. Awan resigned from BCCI in mid-September because he had plans of his own in terms of his career. And he retained separate counsel. He was no longer with BCCI. Indeed, I understand he retained counsel that was recommended to him by this staff. He gave that testimony at the end of September 1988, and just as he had with us, he represented to the committee under oath no money laundering and the like. So it's the kind of testimony you certainly would want the committee to hear. And one final note that I think also is pertinent. Under the U.S. Code, given Mr. Awan's resident status, he was equally subject to subpoena in London and Paris as he was in Miami. It would have same legal force and effect. But I'm glad to have the opportunity to put this on the record, and I thank the chairman.
Well, I think it's important, particularly before this committee, since we're the subject of the inquiry, obviously. Again, for the record, I just want to ask the question, were any documents transferred out of the United States to the London office to avoid production? To your knowledge?
To the best of my recollection, I never heard that. I asked one of the other lawyers in the firm the other day when we heard, I think it was Mr. Sakia, make that allegation, and I think it was the first time he had ever heard it as well.
And again, I want to ask this because I think it's important and the record needs it. Allegations were made with respect to the chairman of this committee being called in order to delay matters. I know that this senator never received any delay instructions from the chairman, but I want to ask you if any phone calls were placed to the committee or in an effort to try to derail this process somehow.
Not by me.
No, sir.
I believe there was one phone
of
call. There was one phone call seeking a delay in which Mr. Jerry Christensen was contacted by somebody. Is that accurate?
Yeah, there was no effort to derail this process. There was a 30-day extension granted, a routine extension.
Do you recall who was talked to in seeking that?
I did that.
And you talked...
Mr. Altman was on the West Coast, and the matter came up about our needing more days. The original subpoena allowed us so few days to gather a very substantial amount of documents. The subpoena had been issued by Senator Pell. His name was on the subpoena. I called Senator Pell, told him the matter. He said he knew nothing about it. I should call Mr. Christensen. I called Mr. Christensen. Mr. Christensen said, I'll look into it. Mr. Christensen then perhaps called your staff, or a member of your staff, and the matter seemed very reasonable, and so I think a 30-day continuance was granted. Now, a very malicious story was planted by someone at that time. I'm sure you're familiar with it. And the malicious story was that this action on my part was done in order to sidetrack the investigation, because if I could get 30 days more, then the tenure of the committee would expire. Totally untrue. So when that statement appeared in the Wall Street Journal, I've oftentimes wondered where they'd get such a malicious interpretation. Mr. Christensen wrote a letter to the editor of the Wall Street Journal, and I won't read it, but it says, Mr. Adams asserts that Senator Claiborne Pell, chairman of the Senate Foreign Relations Committee, frustrated efforts by the committee's special counsel, Jack Blum, to investigate information relating to BCCI's role in laundering drug money from Manuel Noriega. Specifically, he stated that, quote, Clark Clifford pulled strings with Senate Foreign Relations Chairman Claiborne Pell to stall production of crucial documents past the expiration date of Blum's contract with the subcommittee, close quote. Next sentence. That statement is categorically false. That occurs in Mr. Christensen's letter. Then he says that he goes on and tells about it, and he says that after the 30 days was granted, there still remained 6 months of the committee's life within which anything could have been done. So no mistake was made by somebody in planting that story with the Wall Street Journal. It was purposely and maliciously done.
Well, let the record show that Jerry Christensen contacted Richard McCall of my staff, and Dick McCall is the one who authorized it and acted as if it was pro forma, and so I never saw any great conspiracy in it, but you're correct, it has been built up as one.
May we offer this
yeah.
article for the record?
Absolutely. The article will be placed in the record in full. Now, I'd like to draw this in. There are, as I say, a number of questions we want to submit for the record. But here we are. We've got an extraordinary tale that has unfolded. Two distinguished, capable, well-thought-of lawyers who are claiming victimization by this thing. Individuals within the bank who are indeed victims, some of them claiming it. Who knows, distinguishing between the pure victim and the claims, but they are there. You've got two witnesses who've come before this committee who are prior bank employees of long standing who've made allegations. You got Price Waterhouse that by everybody's account has messed this thing up to a fare thee well. You've got the Bank of England that missed a lot of signals, but also has deemed BCCI to have been a, quote, culture of criminality. You've got operating practices that either were with the Fed's blessing or weren't, but no matter what, you've got this sort of integrated operation going on. You've got a National Bank of Georgia purchase, which, like it or not, has turned out to have ties to BCCI through Gaith Ferrone and the question of stock that was pledged and questions of ownership. You've got notice through articles and the regulators as back as the late 1970s that you had serious issues about nominees, and not necessarily that came to your attention, incidentally. I'm just sort of summing up what people are looking at now. You've got the goals and the aims of BCCI as articulated and enunciated by Mr. Abadi in many meetings, as evidenced through the minutes, which we've read today. You've got the annual conferences and sort of this family gathering over a period of years, which included NBG, First American, et cetera. You have questions about the setting of price and the transactions on a sale, again, sort of an insider family operation. You have the use of a flexible front man or two here or there, people who were never met as investors and so forth. You have documents indicating possible BCCI deep involvement in a number of transactions of question and so forth. Now, all of these things have been explained. And my question to you is not to question your explanations, but to say, what do you learn from this? What are we going to learn from this? Where are we in your eyes as a consequence of all of this? What does it mean to you? Did you wear too many hats? I mean, have you learned a lesson perhaps with respect to being lawyers for all of these entities, and that there was a conflict in your capacity to always represent the interests as fully as you might have liked to now in retrospect? Were eyes shut to something along the way here? I mean, what does it mean other than it's obviously a horrible, harassing, ugly, painful event, which both of you would rather not have had any part of? But what does it mean in terms of us and the whole process, if you can shed some wisdom on that at this point?
Let me direct my attention to that, Senator. On June 1st of this year, I had practiced law for 63 years. In 63 years, there had never been a cloud against my name. That was no accident. Particularly 41 years of practice in Washington took the greatest and most particular care to refrain from getting involved in matters that might have affected my reputation and my character. I suggest to you that after building up that record, the furthest thing from my mind would be to permit myself or my partner to become involved in some criminal conspiracy. There was no evidence of any kind to me that any such element appeared. I wouldn't have touched it with a 100-foot pole. To suggest that I would involve my own reputation is bad enough. But even worse, that I would bring in old respected friends like Senator Symington and General Gavin and my friend Quesada, other men of that stripe and nature, and involve them in the kind of mess that BCC had gotten into, I suggest is unthinkable. It just does not tally with one's understanding of human behavior. Now, as far as our not recognizing what was taking place, you may rest assured that I've combed my memory over and over and over in that regard. I do not recall an instance. I do not recall any act on the part of anybody. I do not recall any evidence being brought to our attention which would alert me to the criminal conspiracy that was going on. At the same time, I still have an uncomfortable feeling about it. Why didn't I sense it in some way? I would have wanted to. I've sensed it in other instances in past experience. So that's a purely personal approach to it, but it helps you understand it better. Now, as far as the committee is concerned, I think the committee has rendered a unique and invaluable service to the country. You have brought out the extent of the machinations perpetrated by BCCI. That is a splendid public service. Now, what must we do about it? I think it can be prevented in the future. I think that this can be a situation that can be turned to our country's advantage. It could happen again. Mattingly, Virgil Mattingly, in testimony before a committee said, "It is not too difficult to deceive if you really put your mind to it, and if the deception takes place outside of the United States." I agree to that. But there is within the body of S-1019 the structure and the machinery by which this can be prevented. I think that Mattingly's suggestion that a special unit be set up, and when a foreign bank wishes to enter the United States, that special unit goes into action and gets the facts that we didn't have, the Fed didn't have, the Congress didn't have. So I honor you, I honor the Senator Cook for rendering this service. I want it to lead to a change in the law so that it will not happen again. And in that way, a great many people would be benefited. Even Altman and Clifford would have benefited had it been in existence.
Mr. Secretary, just on that note, I appreciate your comment very much, but with respect to the hats issue, have you thought about that a little more? I mean, if someone is the president of a bank and you are also counsel to the bank, and you are also counsel to an outside bank with whom you are doing business, let us presume that the outside bank entered into an illegal activity for the purposes of this question, and you became aware of it and you're counsel to them. Your duty is to them, obviously, to protect their interests and rights, but those rights may well conflict with the rights of the shareholders of the bank that you are president of. There are 10 variations on that, which as lawyers you both can dream up and imagine. And I wonder if, in retrospect here, you don't sit there and say, hey, you know, that wasn't a good idea, or I wouldn't do that again. Do you have any feelings about the multiple hats?
Yes, these representations flowed very naturally from the 3.5 years of litigation. We occasionally did legal work for BCCI. That was perfectly appropriate. The assignments they gave us were legal assignments, oftentimes regulatory matters. So there was nothing about that representation that in any way, in my opinion, was reprehensible. I do not think that that had any conflict with the representation of the other units that were involved. The major factor here that controlled it all was that the investors, led by Kamal Adam, wished us to take these different positions in assisting them in their efforts. They wanted us to be counsel to First American. They wanted us to be counsel to the 3 shell companies. That was their request. They made a specific request that I become chairman of the board. I think the fact that those functions could be performed together led substantially to the unique success that First American had. We had the information there among those of us who were charged with the stewardship.
I apologize, Mr. Clifford. But you want to do? Senator Brown, we're going to try to wrap this up, so I just want to turn
Mr.
to
Chairman, I
my
had
colleague for a moment. I think he has just perhaps enter in the record.
I had sent to you, through your attorney, a copy of a portion of the House banking report that dealt with wire transfers from Panama, BCCI in Panama, and the allegations involving Secretary Clifford. It struck me that those were two areas that you may wish to comment on, and that I think we would be interested in your comments. We're in the process of wrapping up, and what I would do is simply invite you, if you would, to submit your comments to both of those, specifically what you know about the wire transfers, and secondly, the allegations that appear on pages 21 and 22. They're significant areas, and I think your observations would be helpful to us in those areas.
We shall do so, Senator, and do it promptly.
Mr. Secretary, throughout a political lifetime, I've heard you give a lot of good advice, and obviously you've made many contributions. I must say to you that I can't find myself agreeing just with your last comment on the hats issue, and it's I think just personally that there's an inherent problem with any attorney serving as a president of a bank and as counsel to the bank. I mean, let us assume that the president of the bank himself, and this is not the situation, but if the president of the bank himself were engaged in embezzlement and were the counsel to the bank, there is no way for that attorney to represent the interests of both. And it just inherently, there are management decisions and conflict in trying to implement a management goal, which sometimes runs counter to what legal advice might want to. It's that old notion that only a fool represents himself, and I think you are not that at all, and no one has ever possibly thought that. So I just find it very difficult to find how you can be still so sanguine about the notion of that multiple representation. But that is indeed your judgment, which you have every right to, and I just personally have difficulty doing that. I would like to see, Mr. Bennett, if we could try to work on the issue of those documents, which the committee hopes to be able to get at some time, and we'd like to try to work that out with you. Do you want to respond to me? I don't want to have the last word if you want to say something to me. I'm not trying to cut you off.
Only this. President Truman had a saying that he would use from time to time. He says, the man with hindsight has 20/20 vision. And
that's true.
That applies in this instance. I'm not referring to your comment. But in the climate that existed through that 9 years, the arrangement that we had worked exceedingly well. We didn't have to employ a lot of outside lawyers. We maintained a very economical operation. We watched the dollars that we spent. There were not lavish entertainments of any kind. We didn't waste the shareholders' money. This was a very meticulous, tight operation. And we could do it with the group that we had at the direction of the people. And I say only to you, for 9 years, it proved to be a unique success.
Well, I respect that. Is there any issue that you feel you did not address that we didn't give you a chance to, or that you wish to make as a comment before we close out?
I would make a general observation, Mr. Chairman, and that is that this committee has heard testimony from other witnesses, and I don't want to take the time to be specific about our rebuttal to allegations that have been made. But in general, I would say that the allegations that relate to misconduct on our part, I want the record to be clear that we deny them totally and completely. I find it curious, given the reports that we now have about BCCI, that they have very senior managers who are now appearing before this committee and making these reports, that they were unaware of certain things, but Clifford and Altman had to know them. I find that a rather curious observation on their part. But the record should be clear, we do not accept those allegations, and if there is any particular question about it, we would like to have the opportunity to respond. There have been suggestions made by certain witnesses that we were engaged in influence peddling and the like in order to protect BCCI. Those are totally untrue. There are suggestions that have been made that we condoned obstructions of this committee's efforts or investigations of BCCI. Those are totally untrue, and the record should reflect that that is our view, and as I say, we can detail it. I would conclude with one observation. There certainly have been failings here. It's evident from the enormous controversy that has erupted and the dreadful year that Mr. Clifford and I have each spent. But the system did not fail entirely, and I think it appropriate to conclude with an observation. In this instance, the regulatory authorities have a fundamental objective, and that is to protect the deposits of American citizens. And First American, you see around the world, BCCI depositors standing in line, losing enormous amounts of money. It is a terrible tragedy, and we feel for those people. But First American, as the regulators have said, was run honestly. We think it was run properly. There was no bank that failed. There was no U.S. taxpayer bailout at First American, and no depositor at First American ever lost a cent. So the regulatory authority in this regard did achieve the most fundamental purpose that these regulatory agencies were created, and I think you have to credit them for that ultimate objective.
Appreciate your comment. I'm going to let you have the last word here. I think you deserve it, and I'm going to thank you on behalf of the committee, my colleague particularly, thank him for his patience and effort for coming here. I thank you for coming voluntarily, and I thank you for being patient today. I know this is a difficult process. I also I hope observers will have a sense that we haven't pulled any punches here. We've asked the tough questions that I think had to be asked, but at the same time, I hope you feel that it's been done fairly and appropriately. And with that, we will leave the record open for the submission of any further questions in writing, and I thank you for your appearance today. We stand adjourned.
Mr. Chairman, if I could just say, personally, we very much appreciate both the opportunity to appear and state our side. As Mr. Clifford said, it's very difficult to do that with all of the media, hard for us to get our side across, and in particular, we appreciate the way this hearing was conducted today, the even-handed and fair treatment we've received.
Thank you. Appreciate it. Thank you very much. We stand adjourned.